My
Yes.
Lordship. Lordship, in item number 10, I filed the rejoinder affidavit today, this morning. So Lordship may kindly call for the record.
It will come on the usual course.
No, the matter is fixed today in item number 10, Lordship. Item 10. I filed a rejoinder affidavit against affidavit in opposition filed by the respondent number 1 to 4.
Perfect.
Deeply well.
Please, Your Lordship. I beg to mention item number 3 and 4.
There's one person. There's one person. No. I mentioned the yes, item number
Item number 3 and 4, Your Lordship.
3 and 4. Yes.
My Lord, we are for the petitioner in item number 4. My Lord, the leading counsel, Mr. Panging, is out of station, Your Lordship. Can this matter be fixed after 2 weeks?
Let me say, so that means on behalf of respondent number, behalf of the petitioner. So she submits that the leading counsel, Mr. D. Panging, is out of station.
Yes, Your Lord.
Out of station. She plays for adjournment of the matter being.
After 2 weeks, Your Lordship.
She plays for adjournment of the matter for 2 weeks. Where is allowed this matter after 2 weeks.
My Lord, I also
Item
beg
number 3 and 4, right?
3 and 4, Your Lordship. My Lord, I also beg to mention item number 19.
Item number
19.
19.
Yes, Your Lordship.
Yes, what happened?
My Lord, we are for the petitioner hearing, Your Lordship. My Lord, Your Lordship, Mr. Panging is out of station. Can this matter be
The same fair happened.
My Lord, can this matter be fixed on day after tomorrow?
What do you have to know?
Mr. Panging will be returning back this evening, Your Lord. That is matter. And there's some urgency in this matter, Your Lord.
Please this matter after, release this matter on Wednesday.
Much obliged.
Well, I beg to mention item number 17 and 18.
17 and 18. Yes.
On behalf of T. Tapak, leading counsel is Deepika
Please.
T. Tapak due to medical problems.
Mr. So-and-so appears for the petitioner. And submits that Mr. T. Tapak, the leading counsel, is not keeping well. He pays for listing of the matter after 2 weeks.
After weeks.
After a week, list is matter after a week. Item number
17 and 18.
Lordship, with
say more than 17.
Lordship, with respect to item number 18,
Yes.
in this case, I am appearing on behalf of the petitioner. There is a stay order. It may be continued till the next date.
Item number 18, right? The interim order so fast is extended till the next day.
May I please, Your Lordship? I would like to mention item number 2.
Item number 2.
Yes, ma'am.
Yes.
On behalf of the petitioner side, I took the consent of the opposite party also. May it's the
The motion space.
actually, my lord, in the last occasions, the honorable judge is clearly stated that the submission some citation regarding this matter. So I unable to go through it. So
It's a simple matter. You are for the petitioner.
that's true. I'm the petitioner.
So you are arguing the matter. You will be arguing the matter.
Yes, I am the argument matter.
Why don't you do it? It's a small matter.
Yes, Lordship. Piecemeal settlement, Lordship. Yes. Piecemeal settlement, Lordship.
Yes,
Which is not proper.
They are saying for settlement, but I mean settlement cannot be given in all the cases like that.
Yes.
Yes, yes. For that regard, I need some more time to research and present the citations regarding this matter. After 2 weeks, if possible, ma'am.
This is the second time, Lordship. This is second time.
Second time they are dedicating.
Mhm.
So the argument is for the it's a small matter.
The main thing,
You do it. They will fix it on the. Will fix it. Yeah.
it's too short. Too short.
It's a small matter. Or we can fix it on Thursday.
Friday, if possible.
It's fine. You have four days.
Your lordship, 26, 27, 20.
There is no such complex legal issue. in this case. It's a small matter. We can argue it and we can. Still the- no use pending this matter. You do your research work only. You have taken already time earlier.
That's true.
So come prepared for the person. And you have been already given time. So we fix it on Thursday.
Thursday, your lordship, there is 26 to 27, 8, they are matter in the lower courts. So I unable to appear. So if possible, first Monday
Monday morning.
or Friday, 29 of this month. Friday of this month, 29,
Okay, okay, right.
Friday.
Prayer of, that's what it's saying. Praying, the matter is fixed on. So it's Friday. I should be going. But at PP. This is how it is. The prayer. According to the better is listed on. Next Friday.
Much obliged.
Come prepared.
Fine.
Number 5.
That is to recommend them to the try to get for it.
Prayer of. So, what's your name?
Yes, Viram.
Yes?
Yes, Viram.
So fast. Spend it.
Lordship. Lordship, I beg to mention item number 15.
That one number 15.
Yes, Lordship. In this case, Lordship, conducting counsel is absent due to health issue.
What is your name?
T. Gao, Lordship.
T.
Gao. Yes, Lordship.
Mr. T. The council pertain for the petitioner submits that leading council
Emi Talong. A Talong.
who eight along
Yes, Lordship.
is unable to be present in the court today. Pays for examination of the matter for a week,
Lordship,
please,
yeah.
matter after
Lordship, there is an interim. Maybe
the motor so fast. Is expended till the next.
you'll be obliged.
Your Lordship, may I mention item number 7?
Item number
7.
7.
Yes, yes.
Yes,
Yeah.
what item?
I'm for the petitioner. Since conducting counsel is out of session, so kindly this matter may be adjourned.
What's your name?
M. Kambo, I'm appearing on behalf of Mr. Arsoner.
Item number 7.
Yes, yes.
Your name is not there.
My name is Nodir,
You are appearing on behalf
on
of
behalf of Mr. Raja Sonar.
Mr. So and so, appearing on behalf of Mr. R. Sona. Please for adjournment of the matter.
For 2 weeks.
That's Mr. Sona. It's backup station. It's backup station. You are going to?
Lordship, I'm for the respondent. Respondent
You
number 2.
understand?
T-top.
I posted. I posted itself. It's right both the names. The state and your
Respondent number 2.
respondent
T-top.
number. Prayer is allowed as not objected by the council for the respondents. Please this matter after 2 weeks. Yeah.
Your Lordship, there is an interim order.
Prayer order so fast is standard. If that means better to next day come list of us.
Obliged.
Item number 1, judgment pronouncement.
Is allowed.
Obliged, Your Lordship.
Item number 6, Item number 6,
May I please, Lordship? Lordship, in this case, I am appearing on behalf of the petitioner. Lordship, in our petitioner, we could not mention the GR number. So we have been directed to file
And
additional
You
affidavit.
haven't filed it as yet?
Lordship, the petitioner is working at Calcutta. So we require one more week, Lordship. I'll file affidavit.
Mr.
T Taba.
Pitaba. Pitaba. Learned counsel appears for the petitioner that submits that an additional affidavit was to be filed. The instant matter. However, same could not be filed as yet. It pays for a week's time to file the additional affidavit. The player is allowed to list this matter after the meeting. In the meantime, the the learned counsel will file the affidavit, additional affidavit. Listed after the.
Lordship. Deep
item number 18-9,
May I please, Lordship?
Yes.
Lordship, I am appearing on behalf of the petitioner in item number 8 and 9.
Yes.
Lordship, as per the order of this honorable court dated 23/5/2025,
23?
23/5/2025, that is the last order,
Yes. No, that is not the last.
last to last order.
Yes.
Yes.
May I please, my lord?
Sure.
My lord, I would like to seek for a short passover. Mr. Pita who has not reached this.
What is your?
Lordship,
Let him submit what it.
Yes,
what is
ma'am.
that?
Lordship, as per the last to last order, that is order dated 23/5/2025.
Petitioner was supposed to file an affidavit.
Yes, Lordship, with respect to the payment of rupees 1 crore 70 lakhs. Lordship, we have already submitted, we have paid rupees 1 crore. Yes, Lordship, we have paid 1 crore on dated 24/7/2025. And in this regard, we have filed an affidavit to this effect on dated 21st July.
File an affidavit.
Yes, yes. We have,
For payment of 1 crore.
yes, 70 crore, 70
The
lakhs.
direction was for 1 crore 70 lakhs. What happened to the 70 lakhs?
Lordship, we are contemplating to deposit, but right now due
Okay,
to
let the matter be passed over. for
Lots,
time being.
lots.
Let, the counsel for the respondent.
Lordship.
Okay.
Both the matters same over.
Yes, Lordship. Same.
Why two matters?
Lordship, amount is different.
Amount is different.
Yes,
There are two loans here.
yes,
Two loans.
two loans.
item number 10,
May it please your lordship. This is a challenge to a selection process in a tender matter whereby
Lordship, Lordship, leading counsel is engaged in court number 2. Can you just make them a password for time being?
or I may just continue because
Who is appearing?
Tabatagum, Titagum,
for a
Lordship.
private respondent, your lordship.
How much time it will take?
Maybe half hours.
What?
30 minutes.
So half an hour? Let him be there. After half an hour will take.
Or I could have continued anyways, lordship.
He's not there. So
Yes, Your
after half an hour.
Obliged,
Yeah.
Lordship.
I'll be there
Half an
for
hour.
this matter only.
Half an hour.
Yes, your lordship.
Obliged, Lordship.
item number 11,
Is CDS come?
Yes, your lordship.
Yes, lordship, I'm appearing for accused person, applicant. I'm appearing for accused person,
Yeah,
applicant.
yeah.
Yes.
Yes. So we are ready for the hearing?
Yes,
You are ready for the hearing?
yes, Lord. This accused person has already complied with the interim order passed by our court. Now his statement has been recorded before this IO of the case.
So what was the prayer instance?
Yes, this interim may be absolute and this interim may be disposed, the AB may be disposed. Because already this accused person is appearing before, has appeared before this IO and his statement has been recorded, Lordship.
What was the issue here?
So this kind of criminal
FIR.
It's a case of cheating and criminal intimidations.
yes. Section is the 318(4) and 351. This is the cheating and this criminal intimidation of Lordship. This accused person and this complaint, they are family members, belong from same locality, and they have already settled the case also. During the mid of time, they have lost the affair, and now after that they have settled the case also.
Have settled the case
Yes,
and his statement has been recorded.
yes.
CD is silent about the recording of the statement of the accused. CD is silent.
Is there?
No, complainant statement was recorded, but not accused statement.
He's saying the statement is recorded.
Yes, well, the accused has been appeared before the IO also.
Yes, appear before the IO, that is that, but statement is silent. CD is silent.
Do you have any objection and listen?
Otherwise, your lordship, this is a mutually settled.
He is appearing, he is cooperating with the investigation.
Yes,
Do you have any objection in making this absolute?
no, he
Because
he already appeared before.
He has already appeared.
Yes, I.
But there is nothing on record that like he is appearing.
Yes, it is there. He appeared on the strength of interim bail.
He has appeared.
Yes.
Take care. Yeah, Mr. Kapoor.
Titamin, Lordship.
T?
Titamin.
Heard Mr. P. Unit Council appearing for the applicant. Also heard Mr.
Jita though. Additional VP.
This is an application under section 452 of PMSS of 2023, paying for free and its pay in connection with Sakali PS case number 15 of 2025, registered under section 318 bracket 4 stroke 351 effective at the DNSS to executive. Expenses. The fire was launched. On 26, 2025. By one Sri Labam Sanya, resident of village Parang, TO stroke PS Sagali, Papanpari district AP, alleging that the applicant took the loan amount of at least 1 lakh from the informant and issued a check to payment of the same. That when the informant went to the bank to withdraw the money, the applicant possibly took the proposal check. The told the informant that he would return the money tax. But the money was not paid. Instead of resolving the issue, instead of settling the issue by paying that the person fees 1 lakh, the applicant taken the informant by the consequences by abusing him with thinking agree and prepared him that he will not return back the money. So, pay the money back to him.
No, till that I have no update for regarding payment, but they have settled.
So, settle the misunderstanding. It agrees that. What is that? Therefore, settle the issue. And there is no animosity between the accused applicant and the informant anymore. In view of the above, pays for releasing the accused applicant on bail. Next paragraph. Fight and order dated 4/7/2025. Applicant. The accused Is submitted. He has already appeared before the IO and he has been granted bail on. He has been released on bail. The case file of the case is placed before this court by the learned APP. This court has perused the case diary and seen that the applicant has already appeared on 17/7/2025 for the investigation officer who was being allowed to go on to being so situated and no objection has been made by the level of PPP in making the interim order absolute. This court makes this court makes the order with the 473025 absolute with the following condition. The accused applicant shall make himself available for interrogation by the investigating officer as and when required. Number two, the accused applicant shall not directly or indirectly make any inducement, bid or promise to any person to any the facts of the case so as to receive him from disclosing such facts to the court or to any officer. Any other conditions you want?
No,
Report, any other conditions?
that will be okay.
These two will do, small offense.
Oh, as and when required, you may recall via
In view of the above, this petition is accordingly disposed of as allowed.
published.
Highly obliged.
CD may be written here also. It may be recorded also in other
That order is
CD may be,
CD so received is returned to the original.
yes.
Sorry, sir.
Item number 12.
May I please? On the last occasion, my lord, direction was for the producing of the scanned copy of my lord chart sheet. The chart sheet copy has been, my lord, furnished. Now, my lord, my period
As
is, my
per the office report, the service is not complete.
Yes, madam. Against the victim, madam.
Victim.
Yes.
So that has to be completed. But victim like
It's a POXO, your lordship. Later is,
so this will be served by you.
yes, your lordship. We have taken steps on 21st itself, your lordship, through to the officer in charge from the office of PP, your lordship. We have not received any report as on that, madam.
The third so
my lord, other ways also, my lord, we have already clearly mentioned in the, my lord, the bail applications regarding, my lord, the age,
it's a POXO matter and without hearing
admittedly, my lord.
the victim.
However, my lord, the
This matter
victim is not, my lord, the minor, my lord.
The meeting is fine, but like nothing has to be
Yeah.
stopped. The guardian will be there. Who is the informant interview?
She
She
herself,
herself,
herself, herself.
herself, madam.
Yes.
Victim herself.
The petitioner also heard Mr. T. Okay, Peche, Lanet APP, Lanet APP. Seen the office of, seen the office of 2008-2005. So the service report, R2, is yet to be. Done it, next paragraph. Done it, APP second step. Service is, we have, service that this office has already taken steps for service of campus.
21st of August.
First of August. Let this matter be decided again after.
May I present on 29, madam, Friday, madam. That's because, madam, the accused person is inside the custody even after the completion of the investigation
Let this matter be discussed
on 29.
29.
Madam.
Obliged.
Item number 13,
Madam, I'm appearing for the petitioner, my lord.
CD is there.
Lordship, I have communicated the order, Lordship, but IO, Lordship, he has sick leave, Lordship, so we could not produce the CD today. But Lordship, here, Lordship, the one GST standing council is there, Lordship.
Who?
GST standing council.
GST standing council.
Yes,
Who
Lordship.
is
So,
the GST
he's,
standing council?
Kipatanya, his name should be reflected, Lordship.
My lord, my two submission, my lord. My lord, there was 141, a notice has been issued on me, my lord. I am not a FIR name accused, my lord. My lord, some transaction was with me because he was my chartered accountant. He was maintaining my account, my lord. Then after that, my lord, after issuance of this notice, my lord, which is annexed in page 46, my lord. After page 47, my lord. That is that I have attended the
Mr.
investigating officer.
Counsel,
Yes,
Mr.
my lord.
Counsel, will require the CD in this case.
Obliged, my lord.
CD will be required. Okay, so wait for some time so that like CD can be placed before this court and matter can be heard.
Obliged, my lord. My lord, interim protection of some kind, we will be
Now, when the CD comes, that will be considered.
obliged, my lord. Obliged, my lord.
So and so. Afzal, your name?
Mohammed Afzal Ansari, APZL Afzal. My lord, it is, I will send in the chat box also.
Mr.
Afzal Ansari. Mohammed Afzal Ansari.
Sir, learned counsel preparing for the appears for the petitioner. Mr. MS learned deputy APS for.
And for the state lordship, lordship here, standing council is also there, lordship, his name may be reflected.
But like this party is not there.
Lordship,
Not, I was
yes, lordship, today he is supposed to appear, lordship, I have already communicated to him. Then lordship, on next hearing, lordship, he will appear, lordship, then it's okay, lordship.
So there are only two parties here, state and this.
No, lordship, actually, standing council, lordship, or GST, standing council is there, lordship.
PP doesn't appear.
Actually, I will be performer party, lordship, yeah, because this is GST matter.
But the service is not complete, so no, the CD has not come.
Yes, lordship.
So we post it for the future. Then,
In the meantime, he will appear. Yes, sir.
so and so. As per the office note, 22/8/2025. So, communication was made. Packet 80, packet flow here on 22/8/2025. CD in the instant case is yet to be received, yet to be submitted before the scope. That will be listed after 2 weeks. Who appeared?
Standing counsel of GST, K. Tanya, Ipa Tanya.
So means that. Mr. So and so. Standing counsel. GST, semi-counsel GST. Will appear in the matter.
Okay. Connected.
Accordingly, his name may be shown in the costing.
Yes, Lordship.
According the registry will show his name in the costing. Let the matter be listed after.
Lordship. Apply, sir.
Item number 14.
PCR has come.
No, not yet, Lordship. As well as service was not completed, Lordship. As per the record.
None appears for the petitioner when the matter was called. Let the matter be listed after 2 weeks. So the learned APP, please write to his name. So the learned APP for the state of Arunachal is present. Let the matter be listed after.
Deputy.
Item number 16.
Legal aid counsel was appointed.
Yes,
Is he or she is appearing? Miss R. Pini, Mr. K. Rimi. Who is Miss K. Rimi?
I'm appearing for the petitioner.
K. Rimi,
Remy, he's not present today. Keep her Remy. Legal aid counsel.
is the legal aid counsel has to be there.
Yes, Your Lordship.
She's coming.
No. She's not.
POXO case, this is, that's why legal aid counsel is required.
Legal aid counsel for the victim.
Yes.
Our name hasn't been shown actually in the cause list.
It is there in the cause list also.
This item number
16.
16. Oh, yes, her name is there already there. The paperwork is ready or what?
Your Lordship, in this
Paperwork
case,
is not ready.
charge sheet has been filed and the trial is actually going on. And we are only challenging the fourth FIR that has been registered.
The paperwork is not required.
Yes.
Heard, MS,
Why Bhutia?
so. Then is counsel appearing for the petition. And also.
Jita though.
For the state. It is seen by order dated 9/6/2025 of this court, MSK Rimi was appointed. Rather, the advocate was appointed as the legal aid counsel to represent the respondent number 2, that is victim. Though her name is shown in the cause list dated 25th August 2025, MS Rimi is not present in the court. For ends of justice, let this matter be listed after 2 weeks.
Obligation.
Item number 10. Password for the timing matter.
May it be also.
My lord, before my friend start, my lord, just take to my lord, intimate this honorable court, my lord. This matter, my lord, the government advocate standing council of the RD, my lord, rural development. My lord, recently he suffered a brain stroke, my lord. He's undergoing treatment, my lord. In this regard, my lord, somebody has to be represented. The department has to be represented as a government advocate, and this morning, I talked with the additional advocate general, madam. I believe, madam, he will represent, but the records there of file relating the file has not been handed over to him, and I believe he'll represent the case, madam. So, in that view of the matter, in his
I have something to submit in this regard. I have sympathy with what he is saying, but this argument or this submission that the standing council has suffered brain stroke, it is a fact. But this is a fact that is 3 months prior to what is we are standing today. In fact, the matter has come, I think, for 3 or 4 times in between. The same submission has been made. And this is a department, rural development department. A department cannot be so helpless that they will only have one council. And for next 3 months, at one go, they will go unrepresented. This is a matter where palpable illegality has happened. And unfortunately, there is no interim order to protection. This is a case of supply of materials under MZ NREGA project. Now, if the supply takes place, he's for a private response. If the supply takes place in the meantime, the matter becomes infructuous.
His,
So
name is, his name is shown or not?
His name is
there, Pinter Picha. He's the.
If I also will see the order sheet for a moment, this is the 4th time, I guess. I have not checked the order sheet
The
because I
same
was
submission has been made.
first
and
one,
he,
one
and-
occasion, 2 occasion. I understand.
When did he suffer the brain stroke?
First we'll see the first order, then the second, almost like around 3 months back, Lordship. 2 to 3 months back.
My lord, I
A
believe
department
there
cannot
might
go
be-
this way. I understand a private person appearing with his own counsel, but this is a department, rural development department. I think this is the 3rd or 4th time now. 1, 2, I understand. Twice I would understand, but 4th time I also have my duties for my client, Lordship. This is a matter where there is no stay order. The supply takes place, everything becomes infructuous. Tomorrow the submission will be infructuous. Some balancing has to be done by the department. He is not there. I understand he is not there. He cannot come. They have to engage someone else. Then I'll pray for a status quo lawsuit today.
Sharma,
Yes,
as per the orders passed. See, there was an order passed on 3/7/2025, wherein Mr. B. Picha was there present. Okay. He said that like he filed an affidavit of opposition.
Yes, thereafter, madam.
Then
Thereafter, he
thereafter-
suffered.
21/7, 21/7 submitted that he is not there.
Yes. So it happened like 10 days prior to 21/7.
21/7.
So it's like-
Then 4/8.
4 and probably another date also. I think this is the 3rd occasion or 4th occasion.
For it, I think that affidavit of opposition filed by him that was given to you.
That pleadings were going on in between. But the fact was that
And see, on 14/8, the matter was examined on your behalf.
on my view. I do not know, Lordship. That,
Yeah.
yes, but the fact remains that he is still not appearing.
Sarma, only thing is that like, yeah, I understand your anxiety because like this is a contract matter and like if it is supply goes off, then it will be difficult. But since he has, I mean, without the government.
I understand.
it's like
My-
difficult. And like this person, see, I've seen the orders, but like I think only once he has taken time. Okay, it happened in 2021/7.
Once would mean Lordship.
No, I
He
understand.
is not been,
Like,
the department has gone.
Can it be posted like, I mean, I'll ask him to like, let the additional advocate general appear, maybe tomorrow, day after tomorrow.
My lord, this morning I talked to him, but that required document, concerned file that has not been handed over. I request him, I believe he'll be representing my lord.
But
Because in
somebody,
absence-
somebody from the government should be there.
Yes, my lord, that is
And
there.
this submission is made by
Maybe.
you, being a private respondent.
My lord, that is why, my lord,
Because
I'm
Somebody
making it,
should be there.
Because
Yes.
he is the beneficiary.
He's
No,
the
no.
beneficiary.
I'm making for the first time on the table because I come to know that nobody is representing the department. That's why
Last occasion also, rural development department has gone unrepresented. In fact, from the very day when Mr. Picha has not been able to come, the department has gone unrepresented. I have nothing against Mr. Pichai. I cannot have anything against him. But,
I understood.
but why the department would go in this manner? It has to be represented.
Can you have it on, have it day after tomorrow or Thursday?
Thursday would be. Will it be convenient for Lordship on 29th? That's the, I think, the Friday or
Friday and there are some matters of the kids.
28 or
20th is a hearing day, we can hear it.
or 28. I have a matter fixed in the division bench Chief Justice Court.
Okay, here or in principal seat?
Principal seat. So on 27th, if a Lordship will have it, pleadings are completed, Lordship. Pleadings are completed. Very small issue.
27 will be.
27.
27 will be.
And Lordship,
From the government side, nobody is there, so that that a additional AZ can be informed, intimated.
From Lordship. I'll inform Lordship because now government side no one is here, Lordship.
You intimate the government side, but the government, nobody is representing the government in this case. The government council is required.
No,
That is there is touching council. Should have only about the matter.
yes, no. I'll do the next one.
my apprehension is if supply takes place, I have nothing to argue thereafter. Matter becomes
I
infructuous.
understand. I fully understand.
And the understanding was that affidavits will be filed in a very short time and we will get the matter disposed of. But then because of this
That's
incident,
why interim order was not passed.
yes. The Honorable Court was of the view, let them file it at such and such date. We'll take up the matter and dispose it of as a whole. But
Then
then,
we'll do it. 127 will take it.
Yes,
Please
sir.
intimate.
also will observe in the order itself about this.
I'll pass an order saying that.
Yes. That
saying
the department has to
nobody is
be.
representing. That I'll do. I'll pass the order. And we'll fix it on Wednesday.
Wednesday also. Obliged, Your Honor.
Definitely.
Please record here. Then pass the order. Additional affidavit in reply has been filed today.
I am not filing.
This is please mention that this has been filed and this is put on record.
Obliged.
Item number 20,
Mr. Patil, you are ready with the matter?
Yes. In this case, 30 of 2017.
You please tell me briefly about the
Yes, I'll complete it.
actual stuff.
Judgment was given in favor of the patent. That is before in the court of the senior civil judge, DK. Against of the judgment passed by the senior civil judge, the present respondent made an appeal before the district court. Then the district court found it as reverse against the judgment which was passed by the senior civil judge. Now, against of the judgment and order passed by the district and session judge, we prefer the SRSA, regular second appeal. Now, before coming to that, how the dispute arose? The contention of the respondent
was that they have bought the present land from the present appellate. Now, but the land they have taken from the wife,
From?
wife of the present appellant, whom he has divorced since 2000. Since 2000. And there is a settlement agreement that since she has been separated, divorced each other, she cannot claim any landed property or any other property from the husband.
There was an agreement.
Agreement,
It put reference.
settlement. Yes, it is also in the record. Then she is in 2000 to 2000, we were divorced to each other. She became the wife of someone. Tametar. Tametar.
She married somebody else.
Yes, Tametar. She never possessed.
Exactly, pencil की तो मैं not pencil is not right. तो ये क्या होने हैं? Why is this happening?
She never possessed the land.
Yes.
But in 2006, 2006, do
Yes. She married somebody else. Then
somebody else and become the wife of someone.
yes.
In 2006,
2006.
no,
Yes.
divorce was done in 2000.
Yes.
And 2006, she bought the allotment of the land which I occupied since 1985 till today.
The land was in the name of the husband or the wife.
No, land was under my occupation.
Your occupation in your name.
No, I occupied and she has applied their land allotment by making herself as the wife of President appellant.
Allotment before whom? Before the revenue authority.
Yes, Deputy Commissioner.
Deputy Commissioner, she applied in when? 2006.
26 and
The 2006.
6
She applied for allotment of the land.
land and
And claiming her to be the husband of wife of
the appellant.
wife of the appellant.
Yes,
Right.
never she took the present husband.
Yes.
And then the present respondent, she took the land by way of gifting from my estranged wife. Now she's estranged because she's no longer my wife.
No, whether allotment was given to her.
Given to my previous wife.
The DC has given the allotment to her, to your estranged wife.
Yes,
Then estranged wife has sold the land to the present respondent.
yes. Now, here in the case,
While DC had given the allotment, whether there was any hearing.
no, it was not in the knowledge of the present appellant.
Yes.
Then, while
And she sold the land by executing a deed.
deed,
When?
2006,
Around 6 only.
2000, 2006. And while they have gifted, there is an allegation that the present respondent has paid 2,20,000 to me. Whereas I have not received 2,20,000.
That allegation has been made by whom? The respondent.
Respondent allegation, yes. No,
That
no.
you have received 2 lakh of rupees. Who has claimed so?
The present respondent, they allege that I have received
They
2,20,000.
allege that they have paid you 2 lakh rupees also.
20, 2,20,000.
2,20,000.
And I report it. I report it. Because I am not denying the giving of claim to the present respondent. Because I have given him 120 square meter. 120 square meter. And for that, I received 1,50,000. That much. But demarcation was not made. Demarcation was not made.
No, I mean, portion of the land that she's claiming, the respondent is claiming. First is that wife has sold, your estranged wife has sold some portion of land. Then secondly, some portion of land you have also sold.
No. It was in 2005.
2005,
2005, 120 square meter was given to the present respondent.
present respondent.
Yes, and he was constructed a Kacha building, and due to the
Given to me is like by way of what?
then also there was some money receipt, and final agreement was not made. And upon that, they have constructed a Kacha building.
There was no execution of any deed.
No,
Nothing.
no.
Only on receipt of certain money, you have given the land to her.
Yes.
Land
Now,
land to her, not her.
no, that is the status of
So for that, you have received 1 lakh something.
something.
But you are now they are saying that they have paid you 2,20,000 rupees.
Yeah, that is the allegation, and I am denying it. Now,
This 2,20,000 rupees for which land? Which portion of the land? The land
same plot.
that plot that we have given to them earlier in 2005, or the wife the one that wife has sold.
Same plot. Same plot. Now, that is the status of the case. Then, during the period, the present respondent filed a title civil suit against me. And I also filed a suit against the present respondent. But these two cases, one was registered as title suit number 30 of 2017, and another was 39 of 2007. Now, later on, they seized the same matter, same transaction, same area, same course of action. In that case, the case was, both the cases were clubbed.
Clubbed together and heard together.
Yeah, clubbed together, and I have been made some dependent, and he has been made in planty. Now, that is the case. Now, during that period, while he has filed the petition against me to evict me from the land, he has filed a petition.
Evict you from the land.
Land.
Land was under their occupation.
Land was under my possession. Since 1985, there is no dispute that land is under my possession.
Yes, but some portion of land you have given them and they have built a kacha
but-
house there.
Yeah, they have abandoned it.
They have abandoned it.
They have abandoned it. After abandoned that, they have filed a petition, and their petition is, yeah. This 107.
107.
I paid 107 in extra 4.
Yes, 107.
Yes. What is their petition? For a decree of perpetual injunction against the dependent number 1, thereby restraining him permanently from encroaching the plaintiff land, measuring 374 square meter at P sector Premnagar, Naharlagun, Papupar district, Arunachal Pradesh, duly allocated to her by allotment number such and such. Now, for a decree of mandatory injunction against the dependent number 1 to demolish vacant the part of the building RTC structure and one shop constructed illegally in the allotted plot of plaintiff land. Now, in this plot,
Now this plaintiff is her client. Your client? The respondent. Isn't it?
Yes.
and
In title suit number 30, they have also filed another title suit, 39, which was clubbed together, of course.
Is a club?
Yes.
yes, it is in club together. Now, sorry, okay. Now, here in the case,
This application was filed. Yes.
yes,
Then what happened to this?
here he has not written and prayer come to the prayer part.
Yes.
For a decree declaring the one shop and RTC building structure of the dependent number 1 as illegal and constructed within the allotted plot of plaintiff land 374 square meter. For a decree to dismantle the one shop and RTC building structure of the dependent and cross in the allotted plot of plaintiff land or to order directed the department land, government of Arunachal Pradesh, Tanago to verify the actual enforcement of the plaintiff plot of land. Now see, in this plot, I have been allotted 76 square meter. I got allotment for 76 square meter. Now, he has not identified the plot, whether I am encroaching or not. If he is ascertained that I have encroached the land, why he should make a prayer that directed the department, land, government of Arunachal Pradesh, Itanagar, to verify the actual encroachment. That means he has not ascertained. He has not ascertained. Be pleased to direct the dependent number 1 to pay compensation as to loss of income and damage to the rent house of the plaintiff and cause of
So
the.
without ascertaining, she has gone to file that title suit
Yes,
without knowing which portion belongs to whom.
yes,
And he wanted he wanted that this ascertainment should be done by the deceased of.
done by the department. Now, Order 7, Rule 3
Order 7, Rule 3, yes.
of
CPC.
the plaintiff to clarify Order 7. Yeah.
Order 7, Rule
3.
3.
Rule 3.
Yes. Order 7, Rule 3. Yes, Rule 3 is where the subject matter of suit is immovable property. Where the subject matter of the suit is immovable property, the claim shall contain a description of the property sufficient to identify. In case of property can be identified by boundaries or numbers in record of settlement or survey, the plaintiff shall specify the boundaries or numbers. Yes, I got it.
Yeah.
So boundary should be there
Yes.
when you file a title suit.
Yes.
So it should be when you file at the beginning only, you should ascertain which portion of land is yours.
Yes.
Then you can claim for that portion of land if there is any encroachment.
Yes.
But
Then,
in this case, this thing hasn't happened.
yes. It is one drawback.
Yes.
Second drawback. Since the land is under my possession, without possession of the land, can he file eviction petition against me? At best, he can file for recovery of the possession. But in entirety of his petition, there is no such word for the possession or possession, no title of possession.
There was no pleading to the effect.
No title for possession.
So that means that they were never under any kind of position.
Yes, there is no thing. Now, the question of maintainability. When the question of maintainability was raised, before the original court, the original trial court, it was
The original trial court here was which court? Civil Justice. Civil division. Civil division where?
Ethiopia. It was decided in my favor. It was decided in my favor. That case is not maintainable.
The case is not maintainable.
Maintainable.
That was not decided in your favor.
No. It was decided in my favor.
Decided in your favor.
No, in the trial court, I was defended. He was plaintiff. So the case.
You raised the plea that the case is that suit is not maintainable.
Yes,
So,
it was an issue also. Issue. It was taken into in our lead issue.
there was this maintainability was one of the issue.
Yeah,
And it was decided in your favor.
in my favor.
Yes. Yes, then what happened?
Now, when the land what?
The trial court, I mean civil judge, he has decided in your favor, holding that that title suit is not maintainable because of these two grounds.
No, there is some other grounds also.
But mainly on the ground of
that he cannot be met eviction petition without recovery of the possession and recovery of the possession.
So
and he cannot file injunction without file title suits and for recovery of the possession.
okay, where is the order?
This is page, annexer 3, page 88. Okay. Page 88. And come to the page 95, para 11. Para 11. In instant case, plaintiff has pressed for the decree of perpetual injunction against defendant number 1, thereby restraining defendant number 1 from encroaching upon plaintiff land of 374.5 square meters. Decree declaring one-off an artillery building constructed within suite land as illegal. Decree is to dismantle said one-off an RCC building and direction to land department to verify encroachment, compensation for loss of income by rent and any other relief. From above relief claimed by plaintiff, it can be seen that plaintiff has sought the relief of injunction simpliciter only. He has claimed only for injunction simpliciter. On the other hand, the defendant number 1 has raised the defense that he never sold 374.5 square meter of suite land to plaintiff. The agreement is relied by the plaintiff is false and fabricated. The exact area of land was never finalized and demarcated for the money receipt executed between them in the year 2005, and that his wife had no right to give the suite land to plaintiff, and the allotment granted to plaintiff based on the give deed and related document does not confer any title upon the plaintiff and avert that it is him who owns the suite land. Further, the plaintiff has not been able to establish possession of the suite. Possession of the suite land as PW 1, 2, 3, 4, 5 have deposed that Tenero Assam type rain house constructed by plaintiff in the suite land had vacated said house as same was forcefully occupied by defendant. From above, it is seen defendant number 1 has disclosed in his defense the details of the right or title claimed by him who is raised a serious dispute or cloud over plaintiff title, and plaintiff has not been able to establish possession, but plaintiff has not amended the plan and not converted the suite into one for declaration and possession, and plaintiff has only filed the suit for injunction simpliciter. So his petition was only for injunction, not for possession.
That was the, so that's why it was held that suit is not maintained.
Yes. In instance, since the title is disputed and plaintiff is unable to establish possession, plaintiff ought to have filed a suit for declaration, possession, and injunction. By invoking the law laid down in above referred judgment, it is hereby held that since plaintiff has only filed a suit for injunction simpliciter in instant suit, the instant suit is not maintainable. Accordingly, the issue is decided in negative and in favor of the defendant. Now, when the case is not maintainable, that is the end. Now, after this, when the appeal was made, when the appeal was heard, when the judgment was given, judgment was written, this is judgment of the district and session is in Annexure 1, page 38.
This is impugned.
It is the impugned which I am going to challenge. Now, this is the here. Here in the case, there are two.
So against that order of maintainability and like that dismissal of the suit, they have filed this before the civil court, before the district judge.
Yes,
Then this has gone in their favor.
and this is given
In their favor, and that you are challenging.
yes, and in the judgment while giving, there are two types of documents.
So issue is basically that simple issue of whether without any demarcation or without any asserting, without having a pleading of or clear of reposition, whether a suit can be filed.
Yes,
An injunction can be granted.
yes,
That was the issue.
yes,
And-
yes, very simple. And in that case, here while the judgment was given, the imputation was given, the learned judge, appellate court, has relied with so many documents which was not exhibited in the court.
If you have not exhibited before that trial court.
Yeah. Right. Exhibited and not exhibited. Ah, okay.
In the title appeal, right?
Yeah.
So those documents are relied on in the title appeal. Before by the district judge. So you have some case laws on this?
Yes, no.
As far as documents, if the documents are very relevant, it was not exhibited at that point of time before the trial court.
Yeah.
Then whether that can be taken into account before the taken into account in the appellate stage, the title appeal, or not?
No, that cannot be because it was not exhibited.
We have some cases on that. That's all. It cannot be, but still, if there are some sufficiency to be. No, you can give me later on also, not a problem.
Oh. Now,
Which are the portions, which are the parts that you are really aggrieved by this judgment?
Mama, no. Now, come to page 23.
23? Page 23. Page 23, your application.
No. Yeah. Appeal memo.
Your appeal. So page 23.
Here, they are stating regarding the GP. Even GPs were also not exhibited.
Which was not exhibited?
Not exhibited.
The agreement did.
Agreement did.
Money received.
Yeah. Now, for that the appellant court was here in revising the finding of the original court in regards to the issue of 4, whether the Srimati Yamato Star is competent to give the land to plaintiff, which is now allocated in the name of plaintiff. The plaintiff to prove the
So,
gift.
where are you getting? I'm sorry, where are you? Page 24.
Page 24.
Yes, 24, which this
Here also.
10 or 11?
10.
10.
Okay. The plaintiff to prove the gift of land measuring 374 square meter has not exhibited the gift deed and prove the purported gift deed executed in between the plaintiff and the ex-wife of the defendant apparent head. They have not exhibited it, gift deed. Now, the plaintiff neither exhibited the purported gift deed in between the plaintiff and ex-wife of the defendant, Srimati Yamasoki Tar, nor brought ex-wife before the court to prove gift deed. Thus, the gift of land in between the plaintiff and the ex-wife of the defendant, Yamasoki Yamatar, has not been proved, but the appellant court has relied upon the unexhibited and unproved document which is contrary to the settled legal position. And one more thing, my lord. We have relied the Kaba decision of 2000 and neither my wife agreed upon the Kaba decision, nor I feel it agreed. I feel it is a property decision. If I feel it agreed, I'll go for it. If my wife agreed, she should go for it. Now, they retained the finally.
When was the cabinet decision?
It was in okay. Original conversion is page 186. 186. Handwritten is 186 and type out copy is 188. 188.
No, date.
No. Man.
Which page?
No, my lord.
So cabinet decision was not challenged by anyone.
May I make one submission, my lord?
Yes.
My learned senior may
170 men.
confine to the substantial questions of law formulated by reason. This has nothing to do with the substantial question of law.
Wait,
One second. I'll just, I was about to come to that.
Yes.
Yeah.
Like, which page you said? Which page you said? 117.
Yes.
Yes, now like, let me go to a substantial question of law which has been claimed.
Yes.
So what is that?
Substantial question of
This is order dated 21/11/24. There were 3 questions, 21/11/24.
yes, substantial question of law is only 3. One is
20, you said 21?
21/11/24.
yes. 21/11/2024.
Yes.
Whether first appellate court has acted contrary to express provision of law or binding precedent or ignoring the same in reversing the finding of original court that the suit of mere injunction is not maintainable when the title is in dispute.
This one you are arguing.
Yes.
Fine. The second one?
This in that case, there are series of judgment.
No,
Yes.
What are the other issues?
Other issue, whether allotment of government land by issuing a passbook, confer or create absolute title in favor of the allotee, and whether allotment passbook is a mutation certificate or entry in record or mere mutation of land for payment of land premium and rent. The Arunachal Pradesh Land Settlement and Record Act 2000
So on the issue of, in the issue of the first issue that has been framed, that, I mean, substantial question of law, whether a first appellate court has acted compared to the express provisions of law or by a binding precedents or ignoring the same versus the finding of the original court. That suit is near. So you are arguing in that point.
Yeah.
I have heard you now.
Yeah.
Do you have anything more to argue on that?
And that he has not in the petition.
Because see, like, I can understand that what you are actually submitting is that the documents which have been, which were not before the original court, so that can be taken into account.
And
in reversing the judgment of the original court.
Original court.
So that's what you are arguing. So what
Yes.
was your objection to that?
Mere injunction is not maintainable when the title is in dispute. Now, without any objection raised by both the parties, whether there is settlement made between the parties can be invalidated by the appellate court, because the settlement which we have arrived in 2000, it has been treated as an invalid by the appellate court. But whereas there is no such dispute upon the settlement,
In your name.
yeah, settlement of divorce, both the parties are satisfied, both the parties are accepted. That means
Settlement of divorce.
divorce between the parties. And here in the
And that is
Not the parties here, Lordship. I think there is some confusion, and not the parties here, but between him and his wife.
why?
I'm not included there.
Yeah,
Yes.
it's a stranger wife.
So,
And-
like, what
and
you are
the-
saying is that has been, I mean, that settlement has been
Invalidated by the appellate court.
say as nullity.
Yes. Now, who raised the question? Because just to avoid the cloud regarding the claim of the right of the appellate.
And that in fact that was not raised by any of the parties.
Yes, both the parties are not raising. That is just to, that means in ruling that when there is a cloud, when a person is sought for injunction eviction, he must be a bona fide in possession. There should not be any dispute upon title. Without possessing, the taking of shelter by way of filing eviction is whether it is valid in the eyes of law. In that case, my lord, I have got several rulings that if even in the petition, he has never, in the interpetition, he has never sought for recovery of the possession. Without recovery of the possession of the land in under dispute, how an injunction petition is maintained. Now, second point, whether allotment of government land by issuing a passbook, confer or create absolute title in favor of the allotee. And further allotment, passbook is a mutation certificate or entry in record or mere mutation of lands or payment of premium and rent. Now, now allotment, government allotment, it never conferred title to any individual, but conferred title because it is only on lease given by the government. But in the case of LPC, land possession certificate, issued by the competent authority, in that case, it can be taken as a ownership right. But
So you are submitting the government allotment doesn't give right.
right,
Doesn't give right of ownership.
ownership. It is only on lease.
Only on these.
Yeah.
And in case of which certificate?
Land possession certificate
Land possession certificate is issued by whom here?
by deputy commissioner.
Okay. Land possession. This is absolute ownership.
Absolute ownership.
That is LPC,
LPC.
absolute ownership.
Or actually, yeah. Now, accrual of ownership right on government land allotted for agricultural purpose. Every person who at the commencement of this hold any land from the government for agricultural purposes and his successor in interest shall subject to the provision of subsection 2 of become the owner thereof as and from success commencement. Every person who holds valid land possession document issued by the competent authority outside notified forest shall be entitled to be conferred ownership right on such terms and conditions as may be prescribed. Now, provided that all is
Which provision? Section 88. 88 of Arunachal Pradesh Land Acquisition. AP Land Records Act.
where the Arunachal Pradesh Land Settlement and Report Act 2000.
Okay. The AP. Okay, you have section 88.
Provided that all assets of government land on the date of commencement of the act shall continue to hold such land on lease as per original term of allotment until such a time as appropriate rule for allotment of government
One
land
second, once again, I'm
for purposes
88. This is not the. Itu boleh mau naik ya? Itu boleh mau naik naik kalau itu 2019 case naik. Yes, yes, sorry.
Now, here, as per this act, no title has to be given in the case of the allotment. But the appellate court presuming that
There was an allotment.
there is an allotment and he has got the title. That is the contention and wrong interpretation of that. So my contention is that my submission here in this case is that mutation certificate in the report near mutation of land payment of land premium never conferred any title to the response. Now come to the reported also, I have got the separate ruling. Now come to the third point. Whether a claim can be laid that substantively there was no pleadings of recovery of the possession and consequential relief when the appellate defendant knew the case to be that of the recovery possession and consequential relief.
One thing, Mr. Patil, what is this passbook?
Passbook,
In the second substantive law,
when
it refers to a passbook. What is passbook?
means a passbook is given, a paper is given where the allotee will renew the premium payment that is renew in every year. That is only for the purpose of realization of the fees.
Lease fee.
Lease. This is in 175, my lord.
175.
175. That is the Darwin Chokis case, and you will find the.
Okay, this is the passbook.
Yeah, yes. It is the only 180. That is premium paid by the person for the purpose of realization of the fee.
So in case of government allotment of land, a passbook is also issued.
Yes.
So that the premium can be paid.
Yes.
For the record.
Yeah, that is record for the purpose of recording, for the purpose of realization of the revenue.
Tell me one thing, if whether these allotments can be changed from one person to another person. Once the land is allotted.
When it is by way of gift, because land is allotted in my name, I can transfer it to during a lease period. I can transfer it to my. After that date.
But you said you don't get absolute this thing. Only
that is only for the lease period.
Or only for the lease periods.
Lease period. Within the lease period.
You can transfer it.
Yes.
You can transfer it by way of a transfer deed.
Yes.
Or give it.
Give it.
Or can you sell it? You cannot sell it.
Actually, sale is not permissible.
No, that is what I am asking.
Not permissible.
See, what you have submitted that in case of allotment, it is kind of a lease.
That is the internal discussion between the parties. But in fact, it is not shown to the officer, but it is shown by way of. Now, third point. Whether a claim can be laid that substantive.
But this is but this passbook, this allotment is not land possession certificate.
Yes.
It is not.
No. Because though he got the land passbook, in the entirety of the requisition, you will find that the present appellant is in the possession of the land since 1985 till today. Where is the dispute of possession? They never possessed the land.
Okay. I got it.
Yeah. Now, whether a claim can be, last point is, whether a claim can be laid that substantively there was no pleading of recovery of the possession. And consequently, when the appellant defendant knew the case to be that of the recovery possession and constitutionally. So his intention is he should file recovery of the possession. Where in the entirety of the petition, it is found missing. Without possession, without occupying the land.
Without possession, he is asking for eviction.
Yes,
Without showing his, portion of land.
yes, and even he has to ascertain who is person is that. Therefore, the entirety of the petition.
So
Without matter.
your argument is that possession is a precondition.
Huh?
Precondition for eviction. No, not eviction, but precondition, that you have to show that you were in possession.
Yes,
Then you can ask for recovery.
yes. Yeah, but, yeah, even this.
But that is missing in this case.
Yes. Now, Anatullah Asu Dakar versus P.Busi Reddy, death by and others. That is 2008, volume 4, HCC 4594.
SCC,
HCC,
this is, yes, Natullah 594. And you are relying on which paragraphs?
13,
14, 15, 16,
yes,
and 21.
21,
And this is on which point that you are relying on?
regarding the injunction. Injunction.
The first point,
Yeah.
the first substantial issue, right?
Yes. Now, 13. The general principle as to when a near suit for permanent injunction will lie and when it is necessary to file a suit for declaration and or possession with injunction as a constitutional relief are well settled, we may refer to them briefly. Where a plaintiff is in lawful or peaceful possession of a property and such a possession is interfered or threatened by the defendant, a suit for an injunction simpliciter will lie. If he is in the land under his possession, then it will lie. A person has a right to protect his possession against any person who does not prove a better title by seeking a prohibitory injunction. But a person in wrong possession is not entitled to an injunction against the rightful owner. Now, 2. Where a title of the plaintiff is not disputed, but he is not in possession, his remedy is to file a suit for possession and seek in addition, if necessary, an injunction. A person out of possession cannot seek the relief of injunction simpliciter without claiming the relief of possession. It is very clear where the plaintiff is in possession, but his title to the property is in dispute or under a cloud. Now, here in the case, the title may not be dispute, but he cannot, without possessing the land, he cannot sought for injunction as per the 13.2. Now, 13.3, it is that when there is a dispute of the title, land, in that case, he cannot file injunction petition without filing title suit. Now, cloud, or where the dependent assert title, thereto, and
No, which one you are reading?
13.3.
Yes, yes.
Yes, this or under cloud, under the cloud.
Yes, they for the
Yes,
where the defendant asserts That is there too, and there is also a threat of disposition. Okay. So where the plaintiff is in possession, but his title to the property is in dispute or under a cloud, then what happens?
Yeah, under the cloud or where the dependent assert title thereto. Dependent assert title thereto. And there is also a threat of
So
dispossession.
he has to file a suit for declaration, possession and injunction.
Yes,
But here he has filed only a petition of injunction.
injunction.
Simply cited.
Yes,
He hasn't filed a suit for declaration and possession.
yes,
So that is your case in the
Yes.
first point.
there is one ruling. Another ruling, 2024, HCC,
2024
HCC online,
SCC online,
that is para 23.
online page,
Para 20,
169. Para
23. Further, a suit simpliciter for injunctor may not be maintainable. As the title of the property of the plaintiff respondent was disputed by the appellate defendant. In such a situation, it was required for the respondent plaintiff to prove the title of the property. While praying for injunction, reference can be made to the judgment of this court in Anatula Sidakar versus P. Buti Reddy.
So that was the case you have given me.
Yes,
That case has been relied on.
yes.
Yes.
Now,
And point number 2,
point no,
now you have any more cases? On
Yeah,
point
yeah.
number 1.
point number 2, na?
Now point number 1, you have any other cases? Or these are 2 cases you have well.
Yes, point number 2.
Point number 2, yes. Number 2.
Here, para there is 2021 13 supplementary Supreme Court 135.
2021,
21 test 30, volume 13,
2021, volume 13.
13.
13, yes, 13.
Yeah. It could,
SCC 135
yeah.
and para 23.
Yes,
Para 23 or what?
para 23. It could thus be clear in the
Para 14 also or what?
para 22, para 14, 22, 23.
Yes, 14, 22, 23.
Yes. 14. The issue is no more res integra. The position has been crystallized by this court in Anatula Center. Yes, I have referred it.
Okay, okay. Then,
Yes. Now come to the para 23.
Para 23.
Para 23. It could thus be clearly seen that the High Court in the state order has clearly noted that the parties are in litigation before the civil court and the adjudication of controversy regarding the title of the suit property could be done only by the civil court. The entry with the corporation is nothing more than a fiscal entry relevant only for the purpose of payment of taxes and does not by itself create or extinguish title to the property. The court observed that till such a time, the competent court declared the third respondent Jerry as the true owner of the property. The corporation could not own its own correct the entry after a period of 3 years stipulated under section 114A of the Act. The High Court has therefore set aside the order reserving liberty for the party to have the matter adjudicated upon by the civil court. Hi.
We should not, Mr. Council, we should not print it in the rough papers.
Yes. Now yeah. There is a 2014 volume 2 HCC 269. This is Union of India and others versus Basabi Cooperative Housing Society.
2014.
Entries in revenue report, value of reiterated, do not confer any title. Para 15 to 19.
Yes, let us read 15. What does it say?
It is track law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration and the witness. If any of the case set up by the defendant will not be grounds to grant relief to the plaintiff, the High Court will notice has taken the view that once the evidence is laid in by both the parties, the question of burden of proof fell into insignificant and the evidence laid by the both the parties is required to be appreciated by the court in order to record its finding in respect of each of the issues that may ultimately determine the fate of the suit. The High Court has also preceded on the basis that initial burden would always
Upon the plaintiff.
upon the plaintiff to establish his case, but if the evidence laid is by the defendant in support of their case, probability the case set up by the plaintiff, such evidence cannot be ignored and kept out of the consideration. At the outset, let us examine the legal position with regards to whom the burden of proof lies in a case for declaration of the title.
But how this case is linked to your, relevant to your point, substantial point number 2? The substantial point number 2 that has been already framed is whether allotment of government land by issuing paperwork confers creates absolute title in favor of allotee, or whether allotment is a. So this case is what you are reading. This is regarding evidence. I mean, but how this is relevant to this? These are not relevant, no. The other one also not relevant. Okay. The will sit at 2 o'clock, right now. But like these two cases, like I don't know. Maybe like there is some confusion in this. You check it, check it, because these two cases I find this may not be relevant to the substantial question that has been raised. Okay, so if you check if these cases are not relevant, then you can take these cases back. Otherwise, it will be more. How much time you will take?
Lordship, at the most 30 minutes. I'll try to make it very brief.
Have you checked the cases? Those cases are not relevant. Yeah, now that point number 2.
Yeah, now
we have some other cases. This I'll cut, these two cases. And the ones that you have given me earlier, 2021 13 SSC 135, that is not required. Correct? Not required, that you have taken away. And the other one, the 2014 2 SSC, that is not required. 2014 2 SSC 269, That those have been returned to you, no? So that is also not required. So now you are giving me two more cases, new cases.
Yes, that is,
On point number 2,
point number 2. There is revenue record is not document of title.
so
There is
this one,
223 HCC online 1483 para 12, 13, 14 and 27. Now, para 12, it is tried law that revenue record are not document of title. But this court in Sorani Intercourt held that mutation in revenue record neither creates nor extinguishes title, nor does it have any presumptive value or title. All it does is entitle the person in whose favor mutation is done to pay the land revenue in question. 40. This was further affirmed by in Balwani Chim versus Doulat Chim, wherein this court held that mere mutation of record would not divest the owners of the land of their right title and interest in the land. Now, para 27. This court in Somnath Burma versus S.P. Raju held that possession can be regarded as a better title against all possessors, except the true and lawful owner. Therefore, the multitude of revenue documents put to use to argue that the plaintiff was cultivating the sweet property would not adequately meet the demand of the proof made by law. The only credible document of title laid as evidence in the present case is in favor of the defendant, possession interest. Hence, it must follow that it is only the defendant who can be declared the lawful owner of the scheduled property. Another is entry in revenue record is only for fiscal purpose. For
para 9.
payment of land, 2007, para 9. Para 9. There is an additional reason as to why we need not interfere with that order under Article 136 of the Constitution. It is well settled that an entry in revenue record does not confer title on the person whose name appeared in the record of right. It is settled law that the entries in a revenue record or Jamavan have only fiscal purpose. It is payment of land revenue and no ownership is conferred on the basis of tax entry. So far as the title to the property is concerned, it can only be decided by a competent civil court by Jangturam Bata Hokam. As already noted earlier, civil proceeding in regards to the genuineness of will are pending with the High Court of Delhi. In the circumstances, we see no reason to interfere with the order passed by
Yes.
in the petition. Now, this rule overlap the issue number 2.
Yes.
Now, whether a claim can be laid that substantively there was no standing of recovery of the possession, and consequently, when the apparent defendant knew the case to be that of the recovery of possession and consequently, this ruling, the ruling of NATO,
Point number 3.
number 3. This case is covered in Antula Sudhakar versus P. That is in 2008, volume 4. It's covered.
So that you have given.
Yes, yes, that I have covered. And this much more.
The same paragraphs.
Oh, but, same paragraph. Because they should, in the petition, they should write recovery of the possession, whereas in the entirety of the petition, it is not found. Not to talk of, not to talk of cloud.
That cases I have got now. Now, only thing is that like you can you point me to those relevant paragraphs of the judgment, wherein I mean it has been hold because it has been held differently. We have in the impugned judgment. That particular paragraphs wherein the learned trial court held otherwise.
Oh, yeah.
It starts from page 1 only. Page annex to 1 and page is 1, it starts.
Wait, yeah. No.
The findings are in page 75 onwards of the learned first appellate court,
Page
75 onwards.
the first one.
The order under challenge.
Order under challenge is page.
The relevant portion, I mean.
No, order under challenge from page.
It starts from page 38, but the relevant portions regarding the issues which
Page 38.
yes. The learned appellate court has discussed these issues from page 75 onwards.
Page 75.
Yes.
Page 75 is something else.
This is the order of the appellate court.
Okay. Page 75.
The impugned order. Of course, it starts at page 38, but the relevant portions I'm saying.
Page 75.
Yes.
Yeah. Yeah, yeah. Para 92. While entering the issue number 1,
The issues were same there. The framing of issues were almost same.
almost there.
There are 92 onward. No? Give me the relevant paragraphs. Is para 92 then?
Para 92.
Okay, one thing can be done. I mean, you can give a this thing, written submission also. Can you, will it be possible for you?
Written.
Written submission.
Then we can.
So if you can give me written submission in 2 days, can you give it to tomorrow?
Yeah.
You can give me a written submission tomorrow. She can also give me. I'll hear her.
Yeah.
Then because I'll be leaving in the coming. I mean, on next Friday. So before that, if you give me, I can probably pass the order.
Yes. I will.
I need not carry this, but it may be difficult for.
I'll.
That's all for you. Okay. Yes. Yes.
May I please, Your Lordship? My submissions, my lord, I'll come directly to that. The issue, the substantial question,
Is there, I mean, see, like, first thing is that, little bit of factual thing also you'll have to
yes,
clarify,
yes,
correct? Because
Yes.
there are some disputed.
yes. Our case is, lordship, our case is that initially we thought that the appellant herein is the owner of the land. So that is why we had paid some money, which was disputed by them. We had paid around 2,20,000. There was some agreement which was also executed. But later on, we came to know that the land is a government land. Absolute ownership still lies with the government. That is the nature of the land. One thing I would like to clarify, if your lordship sees the Land Settlement and Records Act, Land Settlement and Records rules, your lordship will know that there are only two types of land in Arunachal Pradesh. One is the village land, or whatever land that it is not notified under the township.
One is village land.
Yeah, village land or whatever land which is not notified in the township. For example, Itanagar.
Not notified in the township.
Yeah, those land which are acquired or notified in the township, those are called government lands. Now, the government lands can be allotted to private individuals for residential purpose, for commercial purpose, for agriculture purpose also. That is why these rules refer to those. Lordship will see the definition of government land also, which is in the rules. I will not refer to that now. Now, Lordship,
Which rules are the rules under this?
the rules which he had referred to earlier, Lordship, the Arunachal Pradesh Land Settlement and Records Act, Act, there is also a rule.
But like you're talking about the act.
Yes, the Act. In the Act, in section 2H, in section 2H, government land has been defined. Then, Lordship, I don't know if it is here. This is the Lordship, the Arunachal Pradesh Land Settlement and Records Rules, which is framed under this Act.
What is the name?
Arunachal Pradesh Land Settlement and Records Rules, 2012. Records. Yes.
So if it is there,
This is just to. There is an Act of 2000. Under this Act, these rules have been framed.
Act 2002, right?
Yes. In the Act is 2000.
Correct. I got it.
Yes.
And rule is
2012. 2012, Lordship.
2012.
12.
But it is written 2002 here. The Arunachal Pradesh Land Settlement and Records Rules 2002.
That, Lordship, this is the prevalent rule now, 2012. Yes.
Then who has given this? Okay, it's our problem.
Lordship, this is only to.
It is the same rules which has been amended.
It seems so, Lordship. This is this is the government publication.
We don't have a copy of that.
No, Lordship.
Should make a copy of it.
Yes, Lordship. I was not, Lordship.
Now, if you are referring.
I will, Lordship, give in the
if you
written arguments, yes.
be
Yes,
available here.
yes,
So you have to give me a copy.
Lordship.
That case.
What I'm trying to say is, Lordship, the status of the land.
Yes.
Status of the land is a government land. The actual ownership still lies with the government. The allottees are only leases. That is true for every.
That has been argued by the learned counsel for the petitioner.
Yes, but learned counsel. But learned senior counsel has tried to impress upon this honorable court, saying that the records which had been maintained, that is the allotment order or the allotment passbook, are mere revenue records. What I'm saying is that is absolutely not the case. Whatever the government is at liberty to allot to anyone, any land, provided under these rules, of course, provided he or she is eligible under the rules. It is not that, suppose I have a son, it is not that automatically my son will get allotment. Of course, it is actually not in the rules, but as a matter of practice, what people do is they gift, make some kind of gift deed towards somebody to whom the land is intended to be transferred.
Whether it is automatically inherited by son and daughters?
No, not necessarily. Not necessarily. It is, Lordship.
During the lease period,
Yes,
if somebody dies,
yes, yes.
it's taken away by the government or like it goes to his son and daughters.
What usually they do is again, I'm saying it's a matter of practice only. It is not discernible from the rules. What they do is they seek the approval of the government and the land and allotment is transferred. Usually what they do. Suppose it is to a non-relative. Suppose somebody has given somebody some land. Actually, it is not within his power to give the land because I am not the owner, so I cannot, I'm also just a lessee. I cannot give the land to somebody. But as a matter of practice, what they do is they execute some kind of gift deed and that is given for approval to the government. If the government approves, then the allotment is given.
Prior government approval is required.
Yes, Lordship. Government approval is required because it is the government land, as opposed to this is as opposed to any other land which is not within the township. This is different from the land which is beyond the township,
It is not notified as.
which is not notified. In such cases, what happens is your Lordship could,
If the village outside the township,
yes,
then what is the process?
outside the township, there is no specific process. It is like a private land, but for the purpose of records, they gave something called land possession certificate, meaning the government keeps a record of rights. This is what the records of right is.
Is it potential for this?
Yes.
All the land is owned by the government?
No, not necessarily. Some lands are private, like I said, for which they apply for.
Private lands can be in the township also.
Lordship, within the township, everything is said.
In Arunachal Pradesh, in Itanagar,
Yes,
there may be lands which are privately owned by people within the Itanagar, and there may be lands which have been allotted to from private person.
no, Lordship.
Private party.
No, Lordship.
What is that?
In Arunachal, if it is within the township, everything is government land. If somebody is residing there, it has to be through means of an allotment order by the government. If it is beyond the township, it can be a private land, a village land, for example. In such a case, there is something called LPC. But it does, LPC means land possession certificate. The government recognizes your right over the land. It is like a record of rights. It is not like in Assam or in other states which I have heard, they keep a records of rights and therefore they have this entry in the revenue records. But here it is not like that. Till now, they are in the process of doing that. So I'm told they are in the process of doing it. But now,
Within Itanagar,
yes,
a person, local person,
yes,
he cannot buy land.
no,
He has to go to the government for
allotment.
if the land is vacant.
Yes. That is the state at the moment.
This is as per the rules here, or act here, or what?
This is as per the rules also, and this is what is known, Lordship. Because there is no other, all the land within the township, there is no private ownership. There might have been earlier, we don't know, but what happened is earlier, yes, in the in the notified township, it is only of the government land. The government is the only owner of the land.
If you want to build a house here, you'll have to take an allotment from the.
Yes, without allotment, you cannot.
Like, what is the lease period usually?
Usually it's 30 years. 30 years.
Extendable.
Yeah, extendable. But till now, I'm yet to see somebody whose lease period has been, whose allotment has been cancelled on this, because usually they extend it.
30 years is quite a
Yes, yes,
quite a less
yes.
time period.
I,
Because a person will build a house there, spending a lot of money and to stay there, his family.
yes,
After 30 years, it's taken back.
yes, usually it is not taken back.
Okay, then.
I'm trying to bring the difference here between the government allotted land and a land, private land, which is not notified outside.
This land is located where?
This is in Naharlagan. This is within the capital complex. This is, if your lordship has seen, there is a hospital there. Just on the,
Naharlagan is outside the township.
no, within the township, very much within the township. In fact, Naharlagan is even older than Itanagar in for township area. It was earlier, it was the capital. It is now shifted to Itanagar. Now it is within the township area. That is why lordship allotment. For private land, there is no question of allotment, because in fact, whether or not you are given LPC or not, it doesn't take away your ownership if you are the owner in LPC, in private lands.
But there is private land in this notified.
Yes, there is no private. That is why I'm saying that with regard to issue number 2, there was a submission made that mutation or just revenue records will not confer any right. Here, the right is given or taken away by the government by an allotment order, by the allotment passbook. When you're given the allotment passbook, that means at least so far as other people are concerned, you are the absolute owner. So it is not a mere record of right. It is not a mere revenue entry. It is conformant of.
So what you are basically submitting that it is different from other states.
Yes, it is. Yes.
States that mutation, whatever mutation.
Yes. Yes. In other states. Yes, in other states, it may apply what he's right in saying that simply revenue records or mutation will not confer any right. But here, the allotment itself confers the right. Yes.
That he also say allotment confers the right.
The allotment itself confers the right. Your ownership, so far as the land is concerned, so far as other people are, as against other people, you are the absolute owner. Only against the government, you may say that government has right to take away the land or not. Other people, as against other people, you are the absolute owner. Now, in this case, what happened is, initially, I thought that the husband, that is the appellant herein, was the owner. Therefore, I approached him and gave him some money, and that has been exhibited also. But of course, he has denied it. That is a different matter. Later on, I came to know that his wife, whom he says is ex-wife, is the allotee of the land. The area was 450 square meters, the total area. Out of that 450 square meters, I was given 374 square meters. The schedule of the land, the wife, the allotee.
Wife is given you by
By way of a gift deed, and it was transferred. It was transferred. Government has approved the transfer, and government has given me the allotment. The passbook.
Was made.
Yes. Your lordship will find my passbook at page 161. At page 161. Yes.
$161.
Yes. This is exhibit. This was exhibited as P Exhibit 6 before the trial court. 162 is my name. Lordship will
I
see.
got it.
Yes.
It was allotted, re-allotted to you.
Yes, re-allotted to me,
2001,
Lordship, not 2001, 2006. 2006,
2006.
yes. This lane was probably allotted to her sometime in the year 2000 because,
So it was earlier allotted to the appellant,
no, his wife,
his wife.
yes.
When it was,
It is not mentioned here, but since this is an only, this is,
it's a relevant fact and information. When was his wife was allotted? This land.
Lordship, that is not, it seems 2000. Because the allotment order, which is mentioned at page 163, is 2000, in the year 2000.
Where page 60?
Page 163,
Page 1.
allotment order. This is a part of that allotment passbook.
Yes, 163, where?
Yes, Lordship will see government land allotment order, number, yes, Lordship has seen, LRB dash 095136/2000 PT 05. I'm saying 2000, Lordship, because the,
Yeah, you are assuming it. This order is not there. Where is the order?
this order will be with the wife of the appellant, which was not told to me, but this was, Lordship will see on the top, allotted plot transferred from Srimati Yamasoki by gift deed against government approved number,
13,
this.
6.
Yes, 2006. So in 2006, she was allotted much before that, it seems, but it was given to me in 2006. 05, 06, 2006.
Understood. Now,
Yes. Now, Lordship,
now when the divorce
divorce took place in 2000.
which date?
Date, Lordship,
Divorce by Keva decision.
no, by some women welfare society. It was not by Keva, by some women welfare society. In fact, it is not even a valid divorce, but Lordship, since we have not, since like he said, we have not questioned.
You have been staying separately
Yes,
from that date because you haven't challenged that.
no, Lordship.
You haven't challenged that and you have been staying separate.
They have been staying separately. I have nothing to do with that.
No, I understand. I'm talking about that wife.
Yes.
Wife
Yes, yes,
staying separate.
yes.
In the meantime, there was some agreement between you and the wife. Some kind of, some kind of discussions happened, and then you took a gift deed from her.
That gift deed in original was submitted to the government for approval. Then approval was given
2006.
in 2006. Now, Lordship, the issue of divorce between him and his wife, in my humble submission, it has nothing to do with the case because it is not that it was a joint property. It is not that he was an allottee and he was an allottee of government land and then the land was given to the wife. It is not that. The allottee was and always was the wife of the appellant. This is not a private land.
Private land that you
Yes, yes. Yes. So the wife was at,
So who allotee is the
yes, he is the owner. This has nothing to do with the marriage. Also, one thing I would like to point out, they have also given, they have also exhibited a document in court, which is of allotment passbook of 2010 in his favor. Lordship may recall, I had said 450 square meters. What
300 and something.
374 was given to me in 2006. In 2010, the remaining 76 square meters was also transferred to him from his wife, from his ex-wife.
What?
Same, by way of gift deed and it was approved and allotment was given to him, and therefore that your lordship will find at page 175. So he also recognizes that the owner of the land, or at least the legal owner of the land, is his ex-wife. If he was at any point, if he, like he claims, at any point that he was the owner of the land, that he was in possession of the land, that the allotment his ex-wife had taken was fraudulent, he could have made any complaint to the government. He said he has been staying there since 1985, and sometime during that time, his wife had fraudulently taken out the allotment. If that is so, then why quietly he has taken a gift deed from his wife for the remaining 76 square meters, and the allotment was transferred to him basing on that gift deed. Your lordship may see page 177. It starts from page 175. This is his allotment passbook. In page 176, your lordship will see the name, Davin Soki. Then in the page 177, your lordship will see on the top,
Transport
from Yamasoki, white gift deed number this, on 5/2/2010. This is a part of that 450 square meters.
So for
This
easily the land was allotted to this lady.
Yamasoki,
Masuki.
Yamasoki is his ex-wife, 74. Yes,
Meaning part she has gifted to this person.
yes, yes.
The only thing is that now he's saying that like
Since 1985, he is in possession and owner of the land.
so he's the owner.
Yes. Now,
By way of possession.
by way of possession.
But now, one more thing comes like since it's a kind of civil matter,
Yes,
possession is very important.
yes,
In Arunachal Pradesh now in Tamil now the land is given to somebody else.
yes,
Another one person is possessing.
yes.
What is the right of the possessor? I mean, the person who is occupying the land.
No right.
If he is occupying the land for last 20 years, 30 years, is there any?
Oh, no matter how long he has been occupying the land. No, lordship, no. At least the rules don't say so. The government is at liberty to allot or not to allot any land depending on their eligibility, of course. That is in the rules. Now, the fact that somebody has been possessing the land will not confer any right. Now, the one pertinent question arises here. In 2010, he has got himself gifted that remaining 76 square meters. In his depositions before the court, he has also admitted that he has never made any complaint against the allotment given to his ex-wife. I am the second person.
Yeah, that,
Eh.
those are factual.
Yes, yes,
Now let us come to that substantial question of
yes,
what is your answer to that? The factual parts I think more or less clear.
more or less clear, Your Lordship.
The things that we have clarified, which was not mentioned by them.
Yes,
Because the one thing is like two gift did happen.
yes,
One gift did actual owner allotee was the wife.
yes,
Then one gift did happen to you.
yes,
Another gift did happen to the appellant.
yes,
Now, only thing is that appellant is the claim of the appellant is that like he's in possession of the land since 1985.
yes,
Right.
yes,
And this land was wrongly given allotted to you.
yes, Lordship. Yeah.
Like this government allotment, the passbook doesn't confer any right.
Yes,
That's what you were saying,
Yes.
is it? You have been saying that. But only thing is that let's see, factual part
yes,
is that.
yes,
So since he was in position,
yes,
he were not in position. Now only thing
Lordship.
is that like as far as the maintainability,
yes,
as far as the maintainability of that injunction that we have filed in
yes,
original court.
yes.
So I mean,
There are two things, Lordship.
so that has been denied to you.
Yes,
So what is wrong in that?
Lordship.
So that the basic issue is that.
Yes. Basic issue is the maintainability. Two things, Lordship. First thing, saying that there is a cloud over the title. because the respondent has claimed, the defendant, because the defendant, appellant defendant has claimed that he has a right over the land, he has questioned the right, the title, sorry, he has questioned the title over the land. So there is a cloud over the title, so therefore injunction
No, see,
also the possession lordship.
go to that injunction petition that you have filed.
Yes,
Yourself, we have admitted that land is not ascertained.
lordship.
The that portion of land was not ascertained.
No, lordship,
That injunction petition, you come to the injunction petition you have filed before the original court.
lordship.
It is at page,
107.
yes. So we come to page 113. This is your prayer.
Yes,
113, number 2.
yes,
For a decree to dismantle the wine shop
yes,
and RCC building structure of the defendant encroach in the allotted plot of plaintiff's land or to order directed the land government of Arunachal Pradesh Itanagar to verify actual enforcement of plaintiff's plot of land.
lordship.
So you have not sought for possession of the whole thing. You are saying that there is an encroachment. And like you are seeking that the government should interfere and find out.
Lordship, he has a possession because the area is of 450 square meters. Some part of it was possessed by him.
So you know that like this portion of land is mine.
Yes,
You don't know.
lordship, the portion of the land, the schedule of the land is mentioned in the land possession land passbook itself.
So why you have not specifically mentioned in this petition, in this injunction?
Lordship, it was not mentioned here, lordship.
So that was the default. That
Yes.
was the default.
Yes.
Was the default whereby
Yes,
the trial court has stated that,
Yes.
That this is not maintained.
Yes.
It is kind of a injunction simplified, and you have not amended that.
yes, that is true, lordship.
So his whole case is on that,
Yes,
and the issue that has been framed by this court,
yes,
substantial question of law.
Yes.
That is also same.
yes. The learned appellate court has reversed this, lordship, on the ground, lordship, that first of all, the title. First of all, the title, saying that since the allotment order itself is a title, so therefore, basing on a third person's claim that he is the actual owner without any other thing to his credit, it cannot be said to be a cloud over the title. So therefore, the petition, the plaint could be filed without seeking for title, number one. Number two, regarding the possession, lordship, it was found in issue number 3, which was tried by the trial court. The trial court, not the appellate court, the trial court has found that earlier the plaintiff was in the plot of land, but this was encroached upon by the defendant by constructing a permanent structure. This issue was held in my favor. After the land was allotted, I was there in the premises, but he had chased me out. This was found in the answer to issue number 3 by the trial court itself. Now, regarding the
This was a finding by the trial court.
lordship,
This was a finding by the.
yes, trial court.
Okay.
Trial court, page 93. It starts at page, sorry,
Page 93 is the decision for the first.
lordship,
So defendant thereupon is there was the appellant. So issue number 3 is whether defendant has enforced upon the plaintiff's allotted land
yes,
by constructing permanent extra.
yes.
Where is the issue? Three.
Issue is lordship, the issue is page 129. Then the trial court's order
Page
start
29, beginning of what?
129. 129.
No, 129, that is fine, but like.
129 is the issues framed by the,
No, but come to page 1, page 98.
yes. Yes, lordship, page 93 onwards. Issue number 1 was decided against me. Issue number 2 was in my favor. Page 96.
Page 98, you are agreeing the main.
Yes, yes. Page 98,
Page 98, 14, paragraph 14.
yes,
You're submitting on that one, no?
yes,
That this was in your favor.
yes, this was in my favor.
Now you show me that like, in spite of this issue,
Yes.
paper, why it was gone against you?
Which one, lordship?
Why this judgment has gone against
On the question of issue number 1, the question of maintainability.
you? See, there is
Despite this,
there is a clear cut finding
yes,
that there was a enforcement by the appellant
yes,
on your land.
yes,
In spite of that,
yes.
why that this judgment has gone against you?
Judgment has gone against me in the trial court on the issue of issue number 1, that is of maintainability. Yes.
So that is the issue.
Saying that,
So that is the issue speaking to me.
yes,
Because that is the issue that has gone to the appellate court,
yes,
first appellate court.
yes,
First appellate court has reversed this,
yes,
saying that like, this is maintainable.
yes.
And how, and I wanted to understand why he said that this is maintainable.
First appellate court,
Of the appellate court, first appellate court. I mean the trial appellate court.
page 75, lordship.
Page 75,
Yes.
from 92 onwards.
From 30,
No, from paragraph 92 onwards.
yes, paragraph 92 onwards. This is the finding of the,
So the relevant paragraph.
page 9, paragraph 92. Then paragraph 93, 93, 94, 95.
Yeah, exactly on the maintainability part, where has he discussed? He is going on and on in this thing only, no? That
Yes.
factual part.
basically paragraph 95, saying that since he's the owner,
Para 95.
yes, para 95.
But this is not correct. She is not in possession of the land.
She was in possession, she was chased out. So at that point, I admit she was not in possession of the land.
Yes. This is a wrong finding then. The only thing is that
Yes,
C means your plan.
yes.
For the allotment, she built a small house there or something like that.
She built a kacha house.
House.
There were some tenants there. They were chased out. So therefore, complaint was made to the police and all, which was of course not exhibited. So I'm not going to say that. I can.
Not in possession.
Lordship. Yes. So Lordship, my argument regarding the possession, Lordship. Lordship has seen the prayer. One of the prayer is to dismantle the RCC structure which he has built. In my humble submission, Lordship, whether that would have been sufficient to ask for repossession of the land. Repossession.
See, if there would have been some pleading,
Yes. Yes.
the prayer portion,
Yes.
if you would have written the same thing, whatever you have written there,
Yes.
and pleadings are there,
Yes.
then the things would have been.
In the
But,
plea,
but in the pleading, can you show me anything that like you have written something like that?
Lordship may come again to 107.
No, 107 is this thing, no?
It-
107 is the
107 is the plaint.
correct. You show me some from there.
Yes. One of the, in the course title, for a decree for mandatory injunction against this defendant number 1 to demolish vacant the part of building RCC and wine shop constructed illegally in the allotted plot of land. It is it is grammatically
You were not there while the matter was taken up in the trial court.
no, Lordship.
So that is missed out.
Yes, Lordship may read this again. For a decree of mandatory
Read it.
injunction to demolish vacant the part of building RCC structure.
Evicting.
Yes,
Evicting is not repossession.
yes, Lordship.
You can write evict them, then give me the give me the repossession.
Yes.
It's not written such like that. You have simply written. So there is not a statement that you were in position.
Lordship,
There is not a statement that you were in position.
there is a statement saying that the
That they have enforced.
Encroach up-
But
thereby set up a bunch of illegally and constructed RCC structure in the plaintiff part of the land. And even to the extent to claim ownership in the well constructed by the plaintiff, all possible attempts to persuade the defendant number of bail he now extends to threatening the defendant and our son of dire consequence. As it shock and surprise that the defendant number one has forcefully encroached the front part of the plaintiff allotted plot of land. Having no alternative left, he has approached the additional district magistrate, Itanagar Capital Complex. In this regard, direction was issued to the officer in charge, Naharlagan, to verify the facts. Has IO G. Basar has recorded the statement, submitted a report on 31/7/2017. On report, it is clear that defendant has encroached part of the plaintiff plot of land. Instead of initiate against the defendant number one, the order directed the plaintiff to approach the competent authority.
you know,
Yeah.
I understood. Now,
Yes.
you show me any case law on this issue.
On this issue, Lordship, on the substantive pleading, Lordship. I'm saying, Lordship,
Issue number one,
yes, on the substantive pleading, Lordship,
if you have any case law,
yes,
which says that it can be done.
yes. I'll have to admit now that,
See, the first question is the first appellate court acted contrary to express provisions of law
yes,
or binding precedents or ignoring the same in reversing the finding of original court. And the suit of mere injunction is that the suit of mere injunction is not maintainable with the title is in dispute. So the only thing you'll have to convince me that in case of a title in dispute or in case of this kind of a dispute, whether a mere injunction petition is sufficient, can be filed without asking for repossession.
Lordship. I'm relying on Lordship, 2008, volume 17, SCC,
2008,
volume 17, SCC 491,
see,
491,
para,
para 13, 15, and 16. This is regarding the,
you don't have a printout of this.
no, Lordship.
Printout of this because while writing the judgment, I will require those things to refer.
Lordship, during the submission of the written arguments, I shall furnish.
Yes, which para 13.
Para 13.
Yes.
The object of issues is to identify from the pleadings the questions or points required to be decided by the court so as to enable parties to let in evidence thereon. When the facts necessary to make out a particular claim or to seek a particular relief are not found in the plaint, the court cannot focus the attention of the parties or its own attention on the claim and relief by opportunity to place the facts and contentions necessary to repudiate or challenge such a claim or relief. Therefore, the court cannot, on finding that the plaintiff has not made out a case put forward by him, grant some other relief. The question before the court is not whether there is some material on the basis of which some relief can be granted. The question is whether any relief proposed by the court could not be granted. When there is no prayer for particular relief or no pleadings to support such a relief, then the defendant has no opportunity to resist or oppose such a relief. If the court considers and grants such a relief, it will lead to miscarriage of justice. Thus, it is said that no amount of evidence on a plea that is not put forward in the pleadings can be looked into by to grant any relief. Then, Lordship, para.
So it goes against you.
Lordship, para 15, Lordship. The relevant principle relating to the circumstance in which the deficiency in or absence of pleading can be ignored was stated by the Constitution Bench of this court in Bhagwati Prasad versus Chandramore. If a plea is not specifically made and yet it is covered by an issue by by an issue by implication, and the parties knew that the plea was involved in the trial. The mere fact that the plea was not expressly taken in the pleadings would not necessarily disentitle a party from relying upon it if it is satisfactorily proved by evidence. The general rule, no doubt, is that where relief should be founded on pleadings made by the parties, but where the substantial matters relating to the title of both parties to the suit are touched, though indirectly or even obscurely in the issues, the evidence has been laid about them. The argument that a particular matter was not expressly taken in the pleadings would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such an objection is, did the parties know that the matter in question was involved in the trial? Or did they lead evidence about it? If it appears that the parties did not know that the matter was an issue at the trial, and one of them had no opportunity to lead evidence in respect of it, then undoubtedly it would be different matter. To allow one party to rely upon a matter in respect of which the other party did not lead evidence and has no opportunity to lead evidence would introduce considerations of prejudice, and in doing so justice to one party, and the court cannot do injustice to another. Then para 16, the principle was reiterated by this court in Ram Saurabh Gupta versus Vishun Narayan.
Read it the same thing.
Yes, Lordship. Lordship, may I still read it? It is well settled that the absence of pleading, even if not only produced by the parties, cannot, because it is also equally settled that no party should be permitted to travel beyond its pleading, and all necessary and material facts should be pleaded by the party in support of the case set up by it. The object and purpose of the pleading to enable adversary party to know the case it has to meet. In order to have a fair trial, it is imperative that the parties should settle the essential material facts so that the other party may not be taken by surprise. The pleadings, however, should receive a liberal construction, and no pedantic approach should be adopted to defeat the justice on hair-splitting technicalities. Sometimes pleadings are expressed in words which may not expressly make out a case in accordance with the strict interpretation of law. In such a case, it is the duty of the court to ascertain the substance of the pleading to determine the question. It is not desirable to place undue emphasis on form. Instead, the substance of the pleading should be considered. Whether the question about lack of pleading, whenever the question about lack of pleadings is raised, the inquiry should not be so much about the form of pleadings. Instead, the court should find out whether in the substance the parties knew the case and the issues upon which they went to trial. Once it is found that in spite of deficiency in the pleadings, the parties knew the case and they proceeded to trial on these issues by producing evidence, in the event it would not be open to a party to raise the absence of pleadings in the appeal. So what I'm saying is, Lordship, I agree it has not been happily worded. I agree that specifically it has not been mentioned that after evicting him, restore me the position. That is not, in fact, it is very poorly drafted. But Lordship, the parties knew, the other party also knew that if he's vacated from the premises, obviously repossession would be there, because the land anyways is in my name. Yes, already allotment is there. Just for the fun of it.
Again, the point.
Yes, just for the fun of it, I will not ask the court to simply dismantle the building, and I will. So I'm saying that what is required is that nobody should be taken by surprise. They knew the case, they were fighting the case on those lines. So only the fact that the repossession has not been mentioned in the plaint, that does not take away my case. So far as again, coming back to the issue number 1, so far as the citation which has placed, Anatula. In Anatula, what has been said is the cloud over the title. Now the cloud over the title,
There is no cloud.
in my case, there is no cloud. So there is no need of asking for title. He has said, number 1, that I have not asked for title. Number 2, that I have not asked for repossession because he's in possession. Those are the objections which is, or those are the grounds on which the learned trial court, the first original court, has rejected my case on maintainability. Regarding the title, like I have stated before. Regarding it, sorry, I would like to place one citation, Lordship, just one.
Regarding
Regarding the Anatula case. Regarding that, the so to say, the antidote to that, so to say. Lordship, 2016, volume 2, I shall give this later on, Lordship. Yeah.
16 volume
Volume 6, volume 12, page 288.
SCC.
Yes. 288. Yes. Para 11, 12, and 18. While referring to referring to the, in this case, Anatula Sudhakar's case was also mentioned, para 12. We are fortified in our aforesaid conclusion by a decision in Kurela Naga, Dhruva Buddhaya Bhaskara Rao, and Gala Jani Kama, wherein this court has examined the question of maintainability of suit for possession without prayer for declaration of title. The court has referred to its earlier decision in Anatula Sudhakar versus P. Buchi Reddy, wherein the plaintiff had purchased the land, suit land and the registered sale deed, and the defendant did not claim the title with reference to any document, but claimed to have perfected the title by adverse possession. It was held by the court that the plea did not prima facie put any cloud over the plaintiff's title, calling him to file a suit for declaration of title. Unless there is a serious cloud over the title of the plaintiff, there is no need to file a suit for declaration of title. The suit for possession was maintainable. The court has held as follows. Then Lordship may skip one paragraph, then that last paragraph from first paragraph from bottom. We may, however, clarify that a prayer for declaration will be necessary only if denial of title by the defendant or challenge to the plaintiff's title raises a cloud over the title of the plaintiff to the property. A cloud is said to raise over a person's title when some apparent defect in his title to a property, or when some prima facie right of a third party over is made out or shown. An action for declaration is the remedy to remove the cloud on the title of the property. On the other hand, where the plaintiff has clear titles supported by documents, if a trespasser without any claim or title, or an interloper without any apparent title merely denies the plaintiff's title, it does not amount to raising a cloud over the title of the plaintiff, and it will not be necessary for the plaintiff to sue for declaration. Then Lordship, paragraph 18. This, Lordship, I will not read out. This is regarding the facts of that case. In the facts of that case, the third person had claimed the lands, claiming to be the adopted daughter of one of the persons who would have inherited the land. So Lordship.
one more thing, like, I mean, before
Yes.
sum up,
Yes.
this Arunachal Pradesh land settlement record rules,
Yes.
which provision you wanted to show?
First of all, Lordship, the definitions. 2.1.
Your primary case is that what I have understood
Yes.
is that land allotment.
Yes.
Allotment is the key.
Yes.
Since the land is allotted to you, and
Yes.
it was not allotted to the appellant,
Yes. It was never allotted to him.
so he doesn't have any right title over the land.
Yes.
And, in Arunachal Pradesh, if the land is, land is allotted.
Yes.
Certain rights.
Yes.
It may not be the full ownership, but it keeps certain rights.
Yes.
So, with these rules, you wanted to show that what you have already submitted.
Yes. With these rules, first of all.
First, the definition.
Yes, definition portion where the allotee has been defined, allotted has been defined. In the first,
Allotted, yes.
yes, allotee, allotted. Then Lordship, land, lease, lessee. This is the second page. Then Lordship, the procedure for allotment. This will Lordship will find in part 10, rule, this is rule 123. 123, this is eligibility for allotment.
That you are eligible, you have been given.
Yes,
See, he hasn't challenged your allotment.
he has said the source from where I got the allotment, that is his wife, did not have, because they were together, because it was his property. So therefore, I could not have gotten that from her, because he's basically challenging the title of his ex-wife, because I got that from his ex-wife.
He's saying that it's my position and she is divorced, he doesn't.
Yes, yes. Yes. See, he's saying that this is in my possession, but the mere fact that suppose he was in possession, even if he was.
Was this estranged wife of the appellant?
Yes.
For the trial court?
She was made a party, but she never appeared. She never appeared. No, she did not come. What I'm saying is the allotment or the title of the land or the allotment of the land has nothing to do with their
120 what?
123. This is the eligibility for allotment. If your lordship goes through the whole rules and the act also, your lordship will not find that a possession, just because somebody is in possession of the land, somebody has a right to be allotted. That your lordship will not find. Because of everything said and done, it is the,
Here,
yes,
can you show me any provision wherein it has been stated about the rights and liabilities of the allotee?
page 123 onwards.
123 is fine. This is
Yes, onwards, lordship.
right of what is allotted land. And
Yes, yes.
Is there any provision on that?
Conditions for allotment are given.
That I have
And then here also, here in fact, conditions for cancellation of allotment is also not, is also given. Only this much, lordship, and how to apply for government allotment.
see now. You are saying that like this allotment gives you right, correct?
Yes,
Now, what are those rights? What are those rights? Now, you are saying traditionally they do give paid and all this thing.
yes,
They do give paid and by way of give paid, they transfer it.
yes,
But if these are in fact approved by the
yes.
government,
That is the reason why
where is provision? Government approval is required.
government approval, lordship, government approval is required for allotment.
This allotment is somebody, then government again modifies their allotment.
Yes, yes, that is why it is written on the top. It is transferred from the, yes.
The provision whereby government can do it.
Lordship,
One thing that you have been submitting,
yes,
that once the land is being allotted to somebody,
yes,
doesn't go to anybody else other than the allotee.
yes.
Anyone.
If somebody,
And traditionally what that has been carried out there is that they used to gift it to somebody
yes,
by gifting. And that gifted is pre-approved
yes,
by the government.
yes,
And that after a pre-approval, a fresh allotment has been made. right?
Yes.
Is to be made.
yes.
So where is the provision? Is there any provision that government pre-approval is required?
I'll have to see, lordship.
That you can check and like give it to me.
Yes, yes, lordship, lordship.
Do you have anything more to submit from you?
Yes, lordship, regarding just one citation, lordship. Sorry. Sorry, lordship. I intended to finish it very quick, but somehow this I have taken a printout. This is
This is on which point?
This is regarding the allotment, the status of a land when it is allotted.
This is from a case from Arunachal Pradesh.
No, this is from Tripura.
That land laws may be different there.
That was also a government allotted land. Your Lordship will find, I'm not going to read just to, Lordship, save the time. Lordship will find the facts in para 6 and 7. In para 6 and 7, in that case, what happened?
6 and 7.
Para 6 and 7 are the facts of that case. In that case, what happened is that the allotment was given to a lady, and that was challenged.
So you are referring to 6, 7 and what?
Paragraph 6, 7 and paragraph 13, 14, 20 and 22. 20 and 22. Yes. In that case, that was also a government allotted land. Government had allotted the land to a lady, and another relative had stayed in that land for more than 30 years. And the challenge was that he was saying that he has a right of adverse possession, that the allotment itself was illegal. In that situation, the court held that the production of the allotment order has proved her title, and by producing Katian's exhibit 2 and 4 also prove her possession. Allotment order is a document of title. It can be accepted as a document of title because that was a government land, as opposed to some other land, like I said earlier, like private land and all.
This is for the court of Tripura.
Yes. Before the Agartala bench. Then, Lordship, in paragraph 22, it is mentioned, admittedly, the respondents are in of the land by way of legitimate right conferred upon them by the government, that without the same being cancelled by the concerned authority as per law, the land cannot be allotted by the government to third parties by following due procedure. In the present case, appellant herein is a third party. During the subsistence of the authorization in favor of the respondents, the appellant has no locus standi to question the authorization issued in favor of the respondents. It was not for this court to decide. It is not for this court to decide the validity of the allotment of land by the government in favor of the respondents in the second appeal. If there is any violation of the conditions or attraction of disqualification, it is for the appropriate authorities to look into the matter. Lordship may also see paragraph 13. This I am not going to read out because to save the time, because later on I'll be giving this anyways. What I'm trying to say, Lordship, is that because of the nature of the suit land, the nature of the suit land here, it is not for the court to cancel or to give allotment to somebody. It is the government, which they have not done. Simply saying that his ex-wife was given allotment, he was in possession, but the ex-wife was given allotment. Simply saying that would not suffice. He did not challenge the allotment given to the ex-wife. In fact, he admitted the allotment given to the ex-wife. That is why in 2010 he got himself transferred 76 square meters of the remaining portion of land. So that is why, Lordship,
You want to basically say that as far as allotment of the land to the wife is concerned, there is no dispute.
yes, he is also not disputed.
Disputed, or he hasn't challenged the request.
He hasn't challenged. He has admitted that in his cross examinations also.
Staying in that land.
Yes. Yes.
He could have applied for an allotment.
Yes, he could have applied.
Check.
No.
So the allotment, since allotment is in the wife's name.
Yes. Yes. I'm saying that, Lordship.
By way of a gift, which is pre-approved by the government.
Yes,
When this allotment was given to you
yes,
by the government, that also he hasn't challenged.
no,
He hasn't challenged that.
no, he simply said that his wife did not have the right to transfer it to me. Suppose,
But he did not approach the court.
no, he did not approach the court. In fact,
It is you who went to the court.
yes, because he was disturbing because he had driven away my tenants.
Challenge that not allowed.
No,
Whether he was aware.
he was aware that is why he got 70 later in a later, my, out of the,
His allotment was 2010.
yes,
Correct.
the area is 450 square meters. 374 was transferred in my name. He was aware. He admitted that in his cross examination.
In spite of knowing
Yes,
that the land is given to you.
yes,
that-
yes. If suppose he says he did not know, suppose he said his wife did it underhand and fraudulently she did. The lane is 450 square meters. Why did not he apply 450 square meters? Why did he only take 76 square meters? He knew that the portion of the land has already gone. That is why he did that. That was subsequent in time. That is in 2010, Lordship. I'm not going to take any more of your time, Lordship.
A lot of things are there.
Yes, yes.
Anything else to say? Okay. Can you please, both of you, please give me written submissions by tomorrow. Okay?
Tomorrow, Lordship. Lordship.
If possible, give me short notes. If not tomorrow, by day after tomorrow.
Lordship. Day after tomorrow, Lordship.
I won't be able to finish writing this.
I will try, Lordship. Lordship.
By weekend, I'll be leaving.
Yes, Lord.
I'll have to carry the whole thing again to.
Yes, Lord.
And it will remain like that for. So if I can finish it here, then it will be better.
Yes.
Give it to me. The earliest, then I will try. I don't know. I have some other things also, but
Obliged, Lordship.
so. Take care. किताब का नाम यूज करने के लिए किताब का नाम यूज करने तो अपने को कॉपी से नहीं है लेकिन अभी ये हम जज के दिया है तो मैंने तो ये इनका तो नहीं लिख दी है अरे लगे तो लंबा पसंद नहीं अच्छा बस तो बस आपसे है मौलूदा वो नॉर्मल किताब भी जज के उसको हम लोग बॉटल ले जो वाला बुलाए तो बस नहीं ठीक है itu orang pun mau sekarang.
Item number 89.
Like you were ready with the hearing?
Yes. Sir, not a lengthy one, so short matter.
Actually, I thought the list is over. I was mentally listening to write some judgments.
So, short matter.
May I please, Lordship?
So you have paid 1 crore rupees.
Lordship.
You are supposed to pay 170 crore rupees.
No, Lordship, some more has to be paid, but Lordship, here in this case, we are ready to pay the decretal amount, but Lordship, since the matter is that we have taken loan from the concerned bank, that is Arunachal Pradesh Cooperative Apex Bank.
See, there is a clear direction from the court that you will be paying this much of money. That is the see. Legal reasoning, the petitioner has shown bona fide so 6 weeks. The petitioner is granted 6 weeks time to deposit. It's a clear order from.
Yes, Lordship.
Yes, 6. weeks from today, the rest of amounts will be reasonable time. So you have not completed the first installment.
Lordship, as per the order and direction of this honorable court dated 23/5/2025, this honorable court has directed to pay 1 crore 70 lakhs.
1 crore 70 lakhs you were supposed to pay, and you were supposed to pay, submit an affidavit in.
Yes, we have already filed an
File
affidavit.
affidavit for 1 crore only, no?
Yes, yes.
Then you were supposed to file affidavit for 1.70 crore.
70 lakhs could not be managed, Lordship. So I need some more time, Lordship. That is my prayer. Because there is no dispute that we are paying the amount.
And he has paid 1 crore rupees.
Yes, Lordship.
My Lord, kindly see the manner in which the
How much, within how much time will pay?
Lordship, this 70 lakhs, Lordship, within 4 weeks, Lordship will pay. Lordship, within 4 weeks will pay, Lordship.
Will you do?
Lordship.
You're saying 70 lakhs within 4
Yeah, Lordship, we are paying.
See,
on-
these are commercial.
yes,
Lordship.
admit to it.
And being adamant.
No.
No.
That's
See, ultimately the board has to be in agreement.
yes, yes,
Sync.
Lordship.
yes.
Then only this will be
Yes.
done. But like if you say, no, you'll have to pay me in 1 week, and he cannot manage, he won't be able to pay me in 1 week, then it doesn't serve the purpose.
Lordship.
That's
So
why
it's better. We give him 4 weeks, give him 4
Lordship,
weeks,
and-
he will pay and file an affidavit, file an affidavit.
Lordship, we are bona fidely, we are paying.
My Lordship will appreciate that it's a 2019 decree. It's 2025, my Lord.
DPO,
Decree of 2019, my
95,
19.
2019.
Yes. We have been cooperating, my Lord.
Because of,
They, in the trial court, they wanted only 6 months time. And in the high court, it's almost 1 year now. Where they sought 6 months time before the trial court. Now, the matter has been pending before this honorable court almost for 1 year now. So we have been cooperating, Malay. It's not that we are not, we are adamant, Malay.
Yes.
We are not adamant.
Lordship, I
We want, they should be, at least, Malay, they should honor the order of this honorable court, Malay. At
Lordship,
least, when they are not honoring the order of this honorable court, your Lordship will imagine what they are doing with the trial courts.
Please pay him, pay within 4 weeks.
yes, Lordship, we'll do that. We'll
4
do that.
weeks.
Yes, Lordship will do that.
Or you pay within 3 weeks.
Lordship,
Otherwise,
4
Malay,
weeks we will do. Lordship.
Otherwise, the petition itself is, Malad, if we really go into the merit of the case, Malad, it's not maintainable at all, actually. So
Whatever will
we have been cooperating, Malad. That's why, Malad.
Lordship, 4 weeks time maybe.
Yes, Malad. We have been cooperating, Malad.
I can see this.
Otherwise, a revision, Malad, there's nothing wrong with the order of the trial court.
Okay, heard Mr.
Titaba,
Peter, Learned Counsel for the petitioner.
Lordship.
Also heard Mr.
Pita for Malad.
Tita for Learned Counsel for the Article for the State Property Index Bank Limited, representing the stand numbers 1 and 2. It is seen from the order with the 23/5/2025 that the petitioner was directed that the petitioner had undertaken, and therefore the petitioner was directed to deposit ₹1 crore 70 lakhs within 6 weeks from the date of passing of the order, and the rest of amounts within reasonable time. Respect. The petitioner was granted 6 weeks time to deposit the amount, which is 1 crore 70 lakhs. The deposit of the amount, the petitioner was directed to file an affidavit providing the proof of payment of ₹1 crore 70 lakhs before the next date of respect. Full stop. Today, no, don't write today. the learned counsel for the petitioner has submitted that he has filed an affidavit
On dated 21st July 2025,
21st July 2025,
page number 149 to
wherein
Lordship.
he has stated that he has deposited an amount of rupees 1 crore on 16/7/2025, correct?
Yes, Lordship, correct.
16/7/2025. However, due to various difficulties, we could not pay the entire amount of 1 crore 70 lakhs. Entire amount of 1 crore 70 lakhs, and thereby he is yet to pay rupees 70 lakhs. He is yet to deposit rupees 70 lakhs. In view of the aforesaid, he is seeking 4 weeks time to deposit the remaining 70 lakhs to the concerned bank. I have heard Mr. P. Tapo, though he has Mr. Tapo, who submitted that though the bank is cooperating with the petitioner for a long time. The petitioner is in fact not abiding by the terms of the decree. Therefore, he submits that petitioner may not be granted more than 4 weeks time for depositing the remaining 70 lakhs rupees. One more thing, I mean, after 1 crore 70 lakhs, there is some more amount to do.
Yes,
16 crores.
Yes, yes, Lordship.
16 crores he has to pay.
How much you have paid now till now?
2 crores 30 lakhs after 16.
What about other money?
That will be deposited in days to come, Lordship.
Where?
Lordship,
But he shouldn't be an example to the public because he's sitting MLA. And if he is such an example, the other borrowers, what would it put an example?
What will happen to the other money?
Lordship, the loan has been taken against the mortgage plot of land, which I have already given to the concerned bank, Lordship. Now the bank is unable to sell that mortgage land.
I don't want
Now-
to go into those details, but it's totally different arguments. If he
No,
wants to
no,
argue on merit,
That's a different.
I'm
Yes.
I'm
That's the
ready
decree against you.
ready to argue on merits,
In terms of the decree, you were supposed to pay.
Yes.
Lordship,
Now that 16 crore rupees is yet to be paid.
Lordship, we are paying, but Lordship, in one go, we cannot do that because we are selling that land, Lordship. Now, some part of the land has been sold, and out of the sale consideration amount, we are repaying
Okay,
back the loan.
okay. May you write? Excuse me. Last line. What? For which time? He also pointed out that the bank had to be paid
16 crores.
16 crores, and out of that, only how much?
2 crore 30 lakhs.
The Lordship, that is subject to correction, Lordship. On the next date, I'll give an affidavit regarding the total.
No,
amount.
after till date 2 crore 30
No, no,
lakhs.
no.
That I have to mention.
No, that he's making a submission, so I can report that.
Yes, ma'am.
And till today, that includes 1 crore.
Yes,
That includes
Yes,
1
yes.
crore.
yes.
And till date, rupees 2 crore. How much? 2 crore. How much?
30 lakhs.
2 crore 30 lakhs.
2 crore 30 lakhs.
2 crore
After filing of this petition.
30 lakhs has been paid.
Yes.
which includes the rupees 1,000 rupees 1 crore that has been paid on 16.
Earlier.
No, this includes 1
Yes.
crore that has been paid on 16/7.
Yes, ma'am. Yes.
16/7/2023.
Yes.
Therefore, he submits that the remaining part of the money is yet to be deposited by the people. I have heard both the parties. Okay, the prayer for 4 weeks time for depositing the remaining amount.
Lordship, 70 lakhs for now, let's say. 70 lakhs, Lordship.
Remaining amount of 70 lakhs. So, 70 lakhs is allowed. Is allowed. The petitioner, the council, the learned council for the petitioner shall file an affidavit in proof of the deposition, proof of the payment of the amount to the concerned bank by the next date. Give a fixed date after 4 weeks. Fixed date the date.
We want the matter to be disposed actually.
On the next date fixed, after 4 weeks. That is 25th of September.
Yes.
25th to 25th of 23rd. 23rd.
There is a vacancy.
After reopening the registry.
Reopen the. Yes.
No, vacation till
Vacation is from 27 September.
okay, then like put it on 23rd or 24th.
Lodge, 23rd.
That fixed.
Lodge.
On the next date fixed, the petitioner will apprise this court about payment of the remaining amount. Remaining amount of remaining part of the decreed amount.
Yes, Lordship, within this 4 weeks, Lordship, 70 lakhs will be paid, but remaining that amount, it will be paid,
You apprise the court how you are going to pay.
Yes.
We cannot keep silent.
Lordship.
You'll have to tell us that when you are going to pay that money. If the decree amount is going on for such a long time.
Yes.
You cannot be silent on that. You
Lordship,
have to tell us that how you are going to pay that amount on the next day.
Lordship.
If
I'm not asking anything from you, but you should give a schedule. You should promise that like, okay, this will be paid on this structured way,
Yes.
this installment. And
Lordship.
court will look into it and court will decide on that.
Lordship.
we are always agreeable to condition they want to put, within 3 months, 6 months, when they want to pay.
What is important is that, see, they are not, this court is not saying that they are not paying or that they are not willing to pay. They are willing to pay, but they need some time.
Yes.
That is correct. They are doing it.
Yes.
And now they have given him pay deposit 1 crore, then 70 lakhs he's saying he'll be paying. But he needs to tell also that like what about the other remaining
Yes.
amount? So he should tell the court that like what will be the payment they will be making, how they are going to make. So then court can decide
Yes,
both,
yes.
both
Yes.
the parties
Yes.
in agreement with both of you and the court. A structure can be made.
Lordship.
We are always agreeable to what the court says, Malo. What I'm perturbed is
Lease this matter on 23rd.
24.
23rd.
When lease this matter on when?
23rd, Lordship. Obligement. Otherwise, Malo, if he were ordinary person, Malo, I would have understood, Malo. He's sitting MLA, Malo. He can't.
No, I mean sitting MLA also has his
No,
own,
no, but
own problems.
but
Because
it's
see, like one thing is also what my learned friend has pointed out. The land has been given mortgage to.
Yes,
no.
Lordship.
Land is with you.
No, he has taken back and that's why I'm submitting one. He has taken back the land to sell. We have even given the NOC.
But he could not sell to you.
Lordship.
But he shouldn't be an example to the public, Malo. That's all. Obligement.
Deep the branch.
I think Mr. Learned Council is fine with the arrangement.
Lordship will try.
Fine. I mean, you come up with some kind, you have a discussion. with the client.
Lordship.
And because see, this is the decree.
Lordship.
And it is pending for a long time. And then like this bank is like public bank.
Yes, sir.
That
Wait,
has to be also given to, I mean, they are, otherwise they will be in problem. No? These are
Lots of-
cooperative kind of banks.
Yes.
Lordship.
Isn't it?
I admit.
So these banks, I mean, they always have the financial funds.
Yes.
a huge amount is gone. So they also have to run.
We are being penalized by
They are for the public only for 40 people.
we are being penalized by the Reserve Bank because of such borrowers. Apply.